Fifth is Lordship, item number 31.
Yes.
Lordship, the item number 31. Lordship. Action
31.
today. Sir, we.
Yes.
31. Lordship. Action today. Lordship.
Action for a day. Yes, Mr. Yes. On the prayer of Mr. Anna.
31.
Learn it. Count for the petition. Yes, pastor for the day. Yes. Amber. Learn it. Petition for the day. Status.
Response has already filed. Response we have filed.
You file.
If the
Six.
Yes. In this case, Malay, today I'm taking steps, Malay.
You wait to pass order.
Item number 45. In this case, we are filing an affidavit in reply. Item
40?
45. 45. Orders matter. No?
Yes.
So 6 and 7 have respondent filed their affidavit in opposition. So we are filing affidavit in reply. 4 weeks time maybe. Some instructions are needed for filing affidavit in reply.
Order for conduct. You are for the petitioner.
Petitioner. I'm a 6 and 7 respondent filed their affidavit in opposition. DC and the Superintendent of Police come.
It just come for service. They will pass the order. And then when it. Then you make the prayer. Don't try to upgrade.
My lord, this matter may be listed for admission on Friday, my lord. The matter pertains
Not Friday, we are heavy Friday.
then Monday, my lord.
Some other. No Monday or Wednesday.
Monday,
Already
Monday.
many matters have been ordered to be listed. Maybe next Friday.
Would my lord permit?
Yeah.
Would my lord permit me to make a mention? My lord, serial number 34. My
Yeah.
lord, my request is, could my lords take it for hearing this afternoon? And my lords had earlier granted a stay on the show cause. And the only issue was whether they had complied with the ASMT 10 procedure or not. Their affidavit is filed, they accept it is not filed. That they have never issued a ASMT 10. My lords, in a very, very narrow compass, it may be disposed of. My lords could take it this afternoon at a fixed time.
That we don't know. We have a list of 60 matters. We'll see.
Very well. My lord, I'll wait my turn.
Possible to implement.
I'll wait my turn.
Your Lordship, with due consent of the other side, Your Lordship, I beg to mention item number 28 of the date. It is
28.
yes, sir. Respondents number 2 and 3 have filed their affidavit in opposition, Your Lordship. We need 3 weeks time to file our affidavit.
No, 20.
This matter, I have for the respondent number 20.
Okay. MS and Mohanto.
Yes.
Learned counsel for the petitioner. And Mr. N.K. Sharma representing Mr. H.K. and Jenny Counsel.
For respondent number 20.
MS Mohanto and petitioner report is granted. How much
3 weeks time.
time? File. Affidavit in reply
Affidavit in-
to the counter affidavit filed on behalf of the respondent. Any comfort?
Lordship, if I may, there's an interim order, Your Lordship. That may
Early the kids after the Indian after
deeply obliged.
Maybe Lordship, item number 32 of daily list may be adjourned for the day.
32. on the prayer of the
Ardeka.
Artica Learned Council Court of Petition. The case is passed for the revenue is available. For
May I please, your lordship, I beg to mention item number 59 and 60, lordship.
in 9 and
Supply.
supply.
Lord.
Yes,
Kindly ask for the day, lordship, 1 week,
your Mr.
P daily, lordship.
on the prayer of Mr. P. Daily Learned Council. The case is passed for the MS Empowerment. Learned. These are 22 matter.
May I please tell, Lordship, this is a listing of matter. Actually, the motion was heard on 18/11/2023. It's a matter relating to non-payment of the subsistence allowance actually while he was taken for the jail actually. It's, civil jail imprisonment. So this matter was last heard on 18th of November.
Subsistence allowance
Allowance not paid.
relating
Before-
to what kind of employee?
Civil employment. No, he is not an employee actually. It's against the state and one bank actually. I think it's a matter of this bench 5 itself actually.
May I please, your lordship? With the consent of respondent counsel, I beg to mention item number 25 of today's,
Item number
25 of today's daily list for 2 weeks adjournment.
you are Mr.
R.S. Chauhan,
R.H. Chauhan.
R.S. Chauhan.
No, you are not R.H. Chauhan.
No, I am not.
Your name
So, S. Chetri, lordship.
as Learned Council. Paying for Mr. R.H. has paid for listing of the case after MS. Then, for the status of it. Then it, and also it, read out, leave the case.
Wait, please, your Lordship. Item 7 cannot be taken up after a week.
On the prayer of Mr. K. Samoa. The council court of petition. Is the case after a week.
Mal.
Who is the
My Lord,
MS
Mr. H.K. Das, I will inform you.
Well, item number 11 to 17, the
Hmm.
barter tax is. The state was
11
on
to 70?
70. It was last listed in March, Malad, it has come up. Can it be on 14, Malad? The AG will make the submission on behalf of the state. Petitioner has already completed their part. Regarding refund,
14. I don't know what is the calendar because I was not there.
some accommodation on 14, Malad. We'll try on.
We don't know how many make.
One.
Necessary. $28 is absolutely blank.
28.
28.
I will have to, Malad, consult with the advocate general. Let it reach, Malad.
Huh?
Let it reach, Malad, I will keep it. 28.
Find out 28 is available.
Lordship, my grievance has been redressed. I want to withdraw this case.
Mr. Ardek, Learned Council for the petitioner has submitted that. As the grievance of the petitioner has been redressed during the pendency of the repeated, the petitioner does not want to raise this petition. Mr. A. Bhattacharya, Learned Council, Revenue and Disaster Management Department for the response number 1. E. Gokul, Learned Council, Finance Department for the response number 2. NMS Empowerment Learned Council for the response number 3. Are present. Mr. Bravo submitted by Mr. Rekha, Learned Council for the petition, ready. Dismissed as now.
Apply.
2019 matter.
Yes, Lordship, these matters pertain to challenge to notices issued by the CBI and ED. 1 and 3 arising from the same facts. 2 is also same facts, but it's a different person. So, Lordship, what has happened? Mr. P.N. Goswami was appearing in these matters. Now, perhaps he will not be able to appear. So, we need to obtain some instructions from the client here.
Need to obtain what kind of instruction?
What is to be done?
Pursue or not to pursue?
What is to be done? Yes, Your Lordship.
Then we can keep it. Otherwise,
Yes.
if it is the question of pursue or not to pursue, then we'll keep it in motion.
Yes.
Right.
Yes. Or Lordship may issue notice, otherwise, Your Lordship. Yes.
So
Yeah,
5
we
years
have
have gone by. So
Yes,
take your
we'll get it,
instruction.
we'll
If
obtain.
the things have proceeded much ahead
Yes,
in the meantime,
yes, sir.
then you
Challenge
take all your instruction also.
I'll also take.
Both of you take instruction. Right? I think that will be better.
Yes.
It is regarding what? Issuance of
Notice.
Yes, notice and summons, Your Lord.
appearance.
Yeah, for appearance.
So whether their appearance are necessary or not, there is a issue.
We have appeared in,
They are not for quashing.
No,
not for,
no.
we have appeared in both,
Ah.
perhaps.
No, it's not.
Not for quashing. If the purpose is served in the meantime, fight out. Both parties.
Not-
Okay. Heard Mr. K.B. Pathak. And the counsel for the petitions. And Mr. M. Haloi. Learned,
Special PPCBI. Special
learned special public prosecutor, CBI. And MS A. Gayon. Learned CGC for the Understanding Council and Enforcement Director for the respondents. And Mr. E. Sharma, learned additional public prosecutor. Oh, sorry. Additional senior government advocate for the state of Assam. State learned council for the parties have submitted that the cases be listed after week in order to complete their instructions. Please, the case. Interim order, anything? Interim
Yes,
order,
sir.
if
There is an interim order.
shall
no.
continue. Please.
May it please your lordship. Lordship, the petitioners and are president and secretary of the Lunsai Ronghang Village Development Committee. Lordship, this is the second set of litigation. Lordship, the second set of litigation. First, the first in the first set of litigation order is at page 42. Lordship,
No, who are you?
I am the president and secretary of the Lunsai Ronghang Village Development Committee. Lordship, and a plot measuring 17 bighas covered by tag number 75, pata number 14.
Now, Village Development Committee.
Lordship,
What kind of recognition it has?
Lordship, it is a committee run by the villagers of that particular area and a certain and a,
One, it is self-style committee or got some recognition?
Lordship,
It is a self-style
Self-style
committee
committee.
or got some recognition
Lordship,
under law.
recognition as per report, it has the recognition. Lordship, kindly peruse the self-style committee. Lordship,
Self-style.
Lordship,
Okay.
kindly peruse page 41. Page 41. Can I go through it?
Hmm.
To the Joint Secretary, Department of Revenue, subject submission of report regarding cancellation of patra. In enclosing herewith the original petition submitted by President and Secretary of Lunsai Ronghang Village Development Committee of Village number so and so under Fuloni Circle Office, I have the honor to submit herewith the land enquiry report on the patra land PP number 14 under tag number 75, measuring an area of land 17 acres 0 kathas 0 lotas regarding cancellation of patra. As per SITA records, it is found that PP has been issued from higher authority of Karbi Anglong Autonomous Council, Difu, so and so, in favor of the private respondents shown in press map herewith copy are enclosed. As per LR report that the petitioner have demanded for cancellation of patta as the land is for burial and cremation purpose of Lunse Ronghang Longarpan area and reissue of new patta in respect of LRVDC for the same plot of land. If the authority so pleases, may kindly be issued for new patta to LRVDC for proposed land at an early date, Lordship.
Yes, what happened there?
Lordship, now kindly peruse page 34, the report of the Assistant Revenue Officer, Lordship. As per the field verification report, it is shown that a plot of land measuring 17 acres bearing DAG number 75 of Longarpan K village in Mauza so-and-so was in the name of the cremation ground. But as per the order dated white memo number, the patta was issued in the name of the private respondents. The applicant is seeking for cancellation of the issued patta of the above mentioned plot of land measuring 17 because of DAG number 75 and patta number 14, and the applicants want to apply to get the patta of the above mentioned plot of land measuring so-and-so in the name of the Lunse Ronghang Village Development Committee Longarpan. Therefore, with your permission, the applicant take a necessary step to get a Miyadi patta in the name of the Lunse Ronghang Village Development Committee. As per the application given by the applicant and after examining the report of the Lat Mandal, it is found correct, Lordship. Therefore, I have submitted the record for your necessary action, Lordship. Thereafter, the petitioners approach this honorable court, Lordship. Annexure J, page 42, Lordship.
Yes.
Lordship, last relevant part is at page 45.
Yes.
After hearing the learned counsel for the parties and considering the entire aspect of the matter, the court is of the view that the petitioner may approach the concerned competent authority of land acquisition for redressal of their grievances, if any, after public notice issues under so-and-so, for referring the matter under so-and-so, with the above observation direction, the restriction exchange dispose of. Lordship, thereafter we approach the concerned authority, Lordship.
No, what is the story?
Lordship, what had happened?
Then some land acquisition proceeding.
Lordship, land acquisition proceeding, Lordship.
Yes, what is?
Lordship, what had happened? The land was previously in the name of the petitioner, Lordship. That is the committee, Lordship. Thereafter, what had happened, Lordship? The private respondent.
It cannot, because it cannot be said it is in the name of the committee.
Lordship.
Because of the report.
Lordship.
You want a settlement.
Lordship.
Of the land.
Lordship.
Meaning thereby, that is not in your name directly.
Lordship.
As per the report.
Lordship. But in the report, it indicates that the name of the private respondent has been included for fraudulent means, Lordship. And thereafter, we have approached this honorable court. Thereafter, this honorable court has asked us to approach the competent authority. And we have approached the competent authority. A case has been registered, Lordship. But the competent authority is sitting over the matter for the last several years, Lordship.
That is Annexure B.
Notification. That the land has been
Who is respondent number 7?
Lordship, respondent number 7 is the Lordship, that is a joint secretary come competent authority for land acquisition, Lordship. The matter is pending before him, Lord. That is
He is a competent authority,
Lordship.
also competent authority.
Lordship.
Hmm?
Lordship, in the page number 26 is also reflect, Lordship. In the notification of Ministry of Road Transport and
Have you annexed the entire? You have only annexed part of the order. A few pages are missing. In the earlier High Court order.
(42 to 46 it is. 42 to
A
45.
few pages are missing. Parties are missing. Name of the party.
Oh, Lordship. That is there, Lordship. On the order part, I have only annexed.
No, who is the competent authority? Whom you have described?
Lordship. It is in the notification, Lordship. In the annexer sheet, page 26, Lordship.
No, Mr. Bordodoi.
Lord.
I am just want to know because your prayer portion is that respondent authorities, more particularly the respondent number 7, shall not be directed to pass appropriate order in a complaint case number 20.
Lord.
Right?
Lord.
And in the earlier order,
Lord.
competent authority, the entire aspect of the name body is of the view that the petitioner may approach the concerned competent authority of land acquisition for redressal of his refund.
Lord.
Right? If any, after public notice issued under 3G. If that is the same authority,
Lord.
then
Same authority, same
And-
notification, Lordship.
then now why earlier you agreed to this order,
Lordship.
right?
Lordship.
Now you are praying that that authority should not pass any order. Because we come to page 45. Who is Kala? Who is Kala?
Joint Secretary of Department of Revenue, my lord. He was appointed by the Ministry of Road Transport.
Same respondent number 7.
7.
Then try to rephrase your prayer.
Lordship.
Come to page 45.
Lord.
You are the petitioners there.
Lordship.
See, after hearing the learned counsel for the party
Lordship.
and considering the entire aspect of the matter, the court is of the view that petitioners may approach the concerned competent authority, that is Joint Secretary Revenue,
Lordship.
of the acquisition for redressal of their grievance.
Lord.
If any, after public notice issued under section 3G of the 1950 Act,
Lord.
for referring the matter to under section 384 of the State Act.
Lord.
So, how this you relate? How this want to relate with this present prayer?
Present prayer is that, Lordship, calling upon the record, issue a rule calling upon the respondent so far as to why the
The,
respondent authorities.
Section 3H4, if I remember correctly, it is regarding apportionment.
Lord.
Suppose 1 bigha plot, 1 crore competent authority has passed an award that for this 1 bigha land, 1 crore compensation is
Lordship.
awarded. Now there are many claimants. So there is a dispute inter se.
Sure.
Then you can make an application before the competent authority. Please refer this matter of apportionment to the principal civil judge, that is district judge. So that is the purport of the order, page 45. Now, what is your exact case?
Lordship, here competent authority is the respondent number 7, Lordship. As
Is
per-
a case of apportionment.
Lordship, it is a disputed land between the private respondents and the present petitioner, Lordship. So after the order, we have approached the competent authority, Lordship. But the competent authority is sitting in over the matter, Lordship. Therefore, we have approached the Honorable Court. That is the case. In fact, Lordship, NSIDCL has also asked the competent authority to pass necessary order, Lordship.
Now, if I have understood it correctly, there is a plot of land measuring about 17 feet.
Yeah.
So before the gazette notification under the National Highway Act, it was marked for cremation ground. And you are espousing the cause of that cremation ground,
Lord.
perhaps, as
Lord.
a village development,
Lord.
right? The notification was issued under what section? 3 small a. Small a. Appointing, I think, competent authority. Competent authority, right? That we are going to acquire this land for the purpose of national highway.
3 capital A is 36 1. Annexure A.
First is page 26.
Oh.
26 May 2020.
20 by the way.
Now, who was the competent authority here?
That has been pilot. The gazette notification was issued by the Ministry of Road
Right.
Transport and Highway.
Who is that? The
Joint Secretary,
officer
my lord.
mentioned in column 2. Joint Secretary.
Joint Secretary Revenue.
Right. So he was appointed as competent authority.
Right.
And it appears that just thereafter, pattas have been issued.
Lordship may look into Annexure A page 36. 3 capital A notification. Published in 24 November 2021.
No, why this private respondent has come?
21.
Okay. Respond number 10 to 14. Obtain pattas on 13/10/2020. Right? That is your case.
Lord. Lord.
After the decision to construct or widen
The
the
national
national
highway.
highway.
Lord.
So you wanted their cancellation.
Lord.
Cancellation of their pattas.
Lord.
Right?
Lord.
So the lands were mutated thereafter in
Lord.
their name.
India name.
That cremation ground.
Lordship.
Cremation ground.
Lordship.
Cremation ground land.
Lordship.
Then what you have prayed is your representation for cancellation of their pattas.
Lordship.
Yeah, and you wanted issuance of patta in your name.
Lordship.
Then you prefer a writ petition.
Lordship.
Let us see it there. The order.
Order starts from 43, Lordship. Regarding detailed report, it is also reflected in the order, Lordship. In page number 44, Lord.
Now, thing has gone a different way.
Lordship.
That the issue of your prayer for cancellation of patta,
Lordship.
of their patta,
Lord.
that has been gone in another direction. There is nothing there.
Lordship.
There is nothing.
Lordship.
So you are not challenging this order.
Lordship, not challenging.
In
Lordship, on
this
the
order of the High Court,
Lordship.
you sought cancellation of their patta.
Lordship.
Rightly or wrongly,
Lordship.
legally or illegally, they have been given patta
Lordship.
by the authority. Maybe after issuance of the notification under National Highway.
Lordship.
Now, there is no prayer as regards cancellation of their patta.
On the basis of the writ petition, Lordship.
Now,
On the
thereafter what happened?
Thereafter, Lordship, we have approached the concerned authority, Lordship. And a case has been registered also, Lord. And written statement was also sought for, Lordship, which is at page 47, Lord. Thereafter, we
Now, see, competent authority appointed under the National Highways Act in the capacity of competent authority is not authorized to cancel patta. Am I clear?
Lord.
Maybe as a Karbi Anglong Autonomous Council authority, he might have the jurisdiction and authority to cancel patta. He may have dual capacity. One, appointed as a competent authority under the National Highways Act by the central government. He is only authorized to calculate affairs, compensation, and award, pass award. And thereafter, if no dispute arises, disbarred. If this dispute arises regarding apportionment between the claimants intersect, then he has to refer it to the principal
civil.
Now, what is your case now?
Lordship, my simple case is that since a order has been passed by this honorable court, therefore, previously I was not the engaged advocate. Lordship. Thereafter, what has happened, they have approached the competent authority, but the competent authority is not passing any order. Let them pass a specific order in this regard. That is my case, Lordship.
Within a month or two, if it is not disposed of, his representation, that case may be disposed of. But the petitioner should approach the my lord competent authority who can cancel the patta, my lord. There is a Assam Land and Revenue Regulation, my lord, specific provision
There
is
is a
there,
hierarchy.
my lord. He can approach them, my lord, for
For
cancellation
cancellation
of
of patta, there is a hierarchy.
He is the
You have gone in
He
a
is not the authority for cancellation of
you
patta.
have gone in a different direction.
Different, my lord.
On the
I
basis,
cannot. This,
My lord.
this order is available. Your whole strength of argument is in a complete different direction.
Lord,
I don't know whether you'll be benefited
Lord.
any manner whatsoever
Lord,
By this order, my lord.
by this
But
order.
he can approach the my lord authority who can cancel the patta.
Right. We are
That
not the
has-
council for the petition.
My lord, my lord.
He is the
My lord,
council for the
my lord. But there is a specific provision in Assam Land and Revenue Regulation, and we have adopted that, my lord.
on the basis of the repetition order of the
No,
repetition,
Mr. Kotoloi, that was reserved as a cremation.
Right.
Okay. That belonged to the autonomous council. In the land record, it was reserved as cremation. And in fact, to protect the cremation ground, they have issued work order also for construction of boundary. It appears.
next sir.
Right? You are the caretaker. Village Development Committee, you used to look after it. But your name is not imprinted in the land revenue.
Then
The cremation ground belongs to the state or autonomous council.
Lord,
Then suddenly, when this widening of National Highway dropped up, authority had issued patta in favor of few persons
private,
in respect of cremation. But land cremation ground was belonged to the government. Now, rightly or wrongly, their name have been incorporated in the land record. Your name is not. You should have been that, yes, this is cremation ground. It should remain as cremation. These pattas were wrongly. But what you have done in the earlier round, that
approach this honorable.
consider our case for apportionment. That is the purport of the order. Competent authority, if any application is submitted by you, it will be referred to the, it should be referred to the competent. Now, competent authority has to decide whether you have valid claim or not.
Lord.
Before, he cannot be a post office.
That is
He cannot be a post office. He has to decide whether you have a valid claim or not to claim apportionment.
that much.
That is the issue. First, before referring, he cannot be a post office.
My lord, my lord.
I have made you understand what it happens. So, yes, Mr. Sutia, has he passed any order or
My
not?
lord, that instruction I don't have, my lord, but it appears that a land compensation claim case number 4/2022 was registered.
Which one? Page?
Case 57, my lord.
Huh.
Jonas Singh Ronghang versus Jari Terang and others.
Who is Jonas Singh Ronghang?
The petitioner, my lord.
This petition.
This petitioner, my lord. On the basis of his application, case was registered.
What
my
is
lord.
this application?
My lord, he has not submitted that, my lord.
Huh?
Application, Lord,
Where is your application?
page 46.
Page 46. What is the pair?
They are on the basis that on 10/3/22, the Honorable High Court had passed an order so and so. Lordship, the Honorable High Court has directed the petitioners to approach the concerned competent authority to redressal of their grievances. Therefore, I pray before your good self to kindly do the needful.
Now,
as
case,
further.
come to page 49. This is addressed to Joint Secretary, whether he is otherwise entitled.
But he is not entitled, but he can forward it to the, my lord, my lord.
Because his prayer, paragraph 12. Please cancel the patta. Paragraph 12, page 49. Now, he has not been addressed as competent
Joint
authority.
Lord Joint Secretary.
Kamkala.
Kamkala. Yes,
Kala.
Kamkala.
Allah is there.
He has registered a complaint case.
Lord,
Let him decide.
Lord,
How can you stop?
Lordship.
You have addressed the
No, no.
complaint.
And has
to him.
not been consulted, my lord. Highway has not been consulted. My lord, only it is, my lord, compensation claim between the two parties, my lord.
Right.
Idea who managing the, my lord, that cremation done part of the cremation of that particular land. Dispute on that, my lord, regarding two parties are there earlier, my lord, that who are managing the, my lord, that committee.
Let an order.
Between them.
See, the court does not want to create more conflict.
Yes,
That is what
my
the
lord.
issue.
Yes, my
The
lordship and direct the,
petitioners and both the parties have
Yes.
created the confusion.
my lord. Lordship and direct the competent authority to dispose of the, my lord, land compensation page number 4 of the 2022
Lordship. That
in a
must.
period of 1 month. My lord.
That what?
That is all.
That.
Well,
If not yet decided.
if not yet.
Heard Mr. P. Bordo. Learned counsel for the petition. And MS Arbor. Huh? Learned CGC. Planning Council. Planning Council. National Highway Authority of India. NHI Socialist Party and National Highways and Infrastructure Development Corporation. For the response number 1, 2, and 8. MS M. Mormon. Planet Junior Government Advocate Assam for the response number 3. Hill Areas Department. 4. 3 and 4. Mr. J. Stutia.
5,
Planet
6,
Standing Council. Karbi Anglong Autonomous Council. For the response number 5,
6, 7, and 9.
and 9. There are parties.
Private, but as the lordship passed the order only to direct to dispose of notice without issuing notice of there being that matter.
But the opportunity of hearing should be extended to them.
To them, my lord.
Lordship. That part.
That part.
In view of the nature of issue involved, raised in this case. And Mr. Podolo, one more difficult. Your prayer is not to pass any order.
Lordship, it is in.
How
No, Lordship.
you can go contrary to your prayer is see your prayer.
It is therefore prayed that your Lordship may please to consider a call for the record, issue a rule calling upon the respondent to show cause as to why the respondent authority is more particular. The respondent,
Okay, directed to pass.
Lordship.
Okay.
That part.
In view of the nature of issue raised and prayer made in this and as agreed to by the land council, appearing for the aforementioned part, the and the order to be passed, there appears to be no necessity to issue to be passed. There appears to be no issue to the respondent number, party respondent number 10 for para. The two petitioners claim themselves to be the president and the secretary of Lunse, Ronghang Village Development Committee, Rongit, Caribbean. It is the case of the petitioner that a plot of land measuring 70 feet and covered by tag number 75 and pata number 40, situated at village Longpor Jan Mouza Guardita, Puloni Revenue Service, District Karbi Anglong, subject. Had been used by the villagers of the said area as a cremation ground since long and are being used also presently. In the year 2014, the Office of the Deputy Governor, Caribbean, sorry, Office of the Deputy Director, in Panchayat and Rural Development Department, issued a work order for construction of boundary walls of the cremation ground that is a subject plot for the purpose of its protection. In the year 2020, the Government of India, the Ministry of Road Transport and Highways, MORT, issued a notification dated 26/5/2020 under clause 1A of section 3 of the National Highways Act and appoint the Joint Secretary within Revenue to perform the function of the competent authority as a competent authority in respect of the National Highway '29 in between the stretch from 49 to 49 kilometer perhaps, not 49 kilometer to 155 kilometer of the Karbi Anglong County within the Karbi Anglong. After issuance of the notification, when is 3A? After issuance of the notification
36, 24.
dated 26/5/2020, the petitioners have alleged that after issuance of the notification dated 26/5/2020, the respondent Karbi Anglong Council Authority issued periodic pattas in favor of the respondent number 10 to 14 on 13/10/2020. The petitioner stated to have filed a representation before whom?
Lordship at page
Yeah.
Annexure D, Lord, Joint Secretary, insert Land and Revenue.
Before the respondent number
7.
7. That is a joint secretary in charge, Land and Revenue Department on 18/10/2021. represented complaint to come on 18/10/2021 and 8/10/2021, seeking cancellation of the patras in favor of the 9 to 14, right? On receipt of the representation, state representative of company, a report was called for from the Assistant Revenue Officer, Puloni Revenue Circle, Puloni, who on within bracket response number 9, who on 16/11/2020 had submitted a report that the village Rungse Lunse Ronghang Village Development Committee wanted to get patta in respect of the subject lot issued in their favor. Full stop. The revenue officer recommended to the response number 7 take necessary steps to get periodic patta issued in favor of Lunse Ronghang Village Development Committee. In the meantime, the MOR and MORT GUI published a notification under section 3 capital A in bracket 1 of the National Highway Act 1950. Declaring its intention to acquire the parcels of land mentioned in the schedule therein, and the same included the subject lot measuring
is 37
Point-
serial number 20.
point
Oh, my God.
7195000 hectare, showing the subject lot as a private plot of land. At that stage, the petitioners approached this court by way of a writ petition, WPC number
1583.
1583 2022. The after hearing the learned counsel for the parties and after perusing the materials on record, the state treatment was disposed of by an order dated 10/3/2020. Most of the relevant part of the order date 2022 read as under paragraph page 45 back number. Subsequent to the disposal of the reputation document number 7, the petition submit a representation to a written state stroke representation before the response number 7 on 21/10/2020, right? On receipt of the said written statement of representation from the petitioners, comma, the response number 7 registered the same as land complaint case number 4/2015. By an order dated 24/01/2023, comma, the response number 7 issued notices to the parties for their appearance before the response number 7. It is in the above background, the petitioner have approached this court by the present writ petition with a prayer for a direction to the respondent authorities, comma, more particularly the response number 5, to pass appropriate order in the land complaint case number, right?
4 of 2000.
4/2022 with the grievance that despite securing the appearance of both the sides, including the response number 9 to 14, comma, impeded hearing
10 to 14.
10 to 14. The same complaint case has not yet been disposed of. Where Mr. Kutia, standing down, AAS has submitted that since on the basis of the written statement of representation 21/10/2020, a case, comma, land complaint case number 4/2020 has already been registered, comma, it is incumbent upon the response number 7 to dispose of the same by passing a speaking order after affording opportunities of hearing to all the parties involved there. So it is submitted by him that if the same state complaint is land complaint is has not yet been disposed of, comma, this reputation may be disposed of with a right to the response authority, the case, more particularly the response number 7, to dispose of the case, comma, land complaint case number 4/2022 within a reasonable period of time. It is submitted by him that the period of 6 weeks would be
4 weeks.
a reasonable period of time.
2 months, my lord. 4 weeks, my lord, for notice, my lord, as per CPC, as an under.
Otherwise, they have appeared. Okay, 8 weeks. 8 weeks. 2 months. 2 months from the date of receipt of a certified copy of this order. Date of submission of a certified copy of this order. Like within a period of 2 weeks. Whereas Mr. Bordolil and the petitioner has agreed to the submissions advanced by Mr. Supriya, standing on case. In view of the such view of the consensus arrived, broad consensus, view of the made by the Planning Council for the party, arriving at a consensus, and considering the fact that the respondent number 7 is already in season assigned season of the case land complaint case number 4 2020. The same can dispose by directing the authority the authority particularly the respondent number 7 to dispose of the case land complaint case number 4 2022 after within a period of 2 months after affording due opportunities to all the stakeholders, including the petitioners and the respondent number 10 to 40. This could, it is accordingly ordered. It is further observed that the period of 2 months shall be from the date of submission of a certified copy of this order at the by the petitioners at the office of the respondent number 7. So, that will do. Okay, like you go, MS start the also make similar above observing and observing it and direct given to direct.
Obliged.
For time, I'm very for the bit. But you kindly pass over the matter for time.
Time being.
That matter has come from Kolkata, my lord. So
Okay, when he will be available.
now he is select in court number 1.
Okay, before the Chief Justice. Honorable.
Chip, kindly pass over the matter for time being my senior.
Timing will be difficult to revisit again. We have so many matters. Some other day.
Mr. Sharma was here.
Huh?
Mr. Sharma was here.
Yes, somebody made prayer amount. Yes,
We have taken the today itself, Lord.
we
Today
have taken steps. Your name, please. Heart. Your name?
D. Datta.
D. Dotto.
D.
D. D. Dotto. Learned Counsel for the petition. And MS M. Bormon. Learned. Senior Government Advocate Assam Patel. Your name should be reflected. You are my officer in charge. Police station. Panbajar. Here is the office note dated 25/4/2020. MS Dr. Lion Kasarpata has submitted that the an opportunity be allowed to take steps for service of peace upon all the respondents in terms of the in deference to the order dated 26/6/2020. It is submitted that such opportunity granted the steps to be taken during the course of the day. The petition shall be taken for service of peace upon all the respondents in deference to the order dated 26/6/2020. Allowed take the steps for service of peace upon all the respondents in deference to the order dated 26/6/2020. Within 2 working days from the name of
Yes.
government of Assam be reflected in the College. Please again.
Requisite copies may be served at the end.
All the it is already ordered.
Fine.
The petitioner shall have a copy of the report to the learned senior government to MS Burman.
Public.
And in court. Also.
In this case, pleadings are complete. I have filed my affidavit.
That is a subject matter.
My lord, this is basically seniority.
Seniority.
So,
Yes,
it can be fixed for a hearing day for final disposal.
final.
He is not ready. He is not ready. Not like ready, my lord. I thought since it's a motion day, my lord. So that's why.
E Burman. Each get a one and or and we can start from your private.
Yes.
Very comfort. Is the case on
I am appearing for phone number 3 Rajib. We have drafted our affidavit and submitted for vetting before the register. So I pray for
how much
3
time?
3 weeks. I mean the file and
Will record and it is submitted for vetting.
Yes.
Part Mr. A.R. Gugoi, Council of Opinion. M. Normal. 1. MS. 8 Taluta. And a junior government advocate. For response number 1. Any finance? No finance. B. Group. That is spending of finance part for Third.
A Borua.
A. Borua. Learned council bring on behalf of Mr. Moto. And it's the Borua. Paying for the draft deputy ministry has been sent for vetting and the same He has not paid for after prayer after is the case of kind of that is part number one. They also file their affidavit on our report. And two has filed already.
Who has filed it?
Obliged.
I am appearing for the petition. The matter GST Act, it is under the TTST Act matter. Here I am challenging the order of adjudication order and the notice of summary, notice, show cause notice. Because what has happened, they have not issued, while issuing the show cause notice and order, they have not followed the rules prescribed.
No, show cause notice.
Yes,
Demand comes show cause.
my lord.
Demand comes show cause notice.
Demand comes show cause notice, my
So
lord.
did you submit
I have
reply
submitted-
in
I have
response to that?
submitted- Yes, my lord, I have submitted a reply. Thereafter, they issued an order also. But my lord, my submission is that in the show cause notice, while issuing the show cause notice and the order, they had not followed the rule prescribed under the 142, which is mandatorily, they are supposed to issue the summary of notice in DRC 01 and the demand notice
Did
in
you
DRC.
raise that issue in your reply?
No, my lord, that in my reply, it has not been raised,
Then-
my lord.
Then
My lord, my lord.
what is the law then?
My lord,
What is the law?
my lord, may I?
Tell me. No.
142.
No, not 142. Maybe in the statute. If at the issuance, at the time of issuance of the demand comes show cause notice,
Yes,
suppose that prescription was not followed.
not.
You replied to the demand comes show cause notice.
Yes, my lord.
Did you raise that point?
My lord, may I? My lord.
Did you raise the point? Yes or no?
my
That
lord,
can be
I have not.
answered.
I have not read. I have
Then
not raised.
order in original is passed.
Yes, my lord.
You participated in the proceeding.
My lord, only reply has been submitted, my lord. No hearing, personal hearing.
Did you ask for?
My lord, no, my lord. In
Did you
my
ask
reply-
for?
No, my lord. The reply has been submitted according to the order on original, my lord. The date of personal hearing when it was granted, I filed my reply after
No, let
that.
us see
my
the demand come show
My
cause notice.
My lord,
Oh, this
the
is
page-
audit. No, here.
This is page 89. Start from page 89. My lord.
No, first it is 29.
My lord, this is the audit proceeding. Initially, there was an audit
This
proceeding
is under what?
under section 65, my lord. That audit
60?
proceeding, 65, my lord, 65 of the CTST Act, my lord. Initially, there was an audit proceeding. I attended the audit proceeding. There are certain observations made by the audit authorities. Some of the portions I accepted, a few and made the payments accordingly. Thereafter,
Okay, this audit or observation was made. Then what happened? You replied to it
yes,
or
my-
what?
my lord, page
Corrigendum
88.
to audit observation.
My lord, page 88, my reply to the
Reply to
final
the audit observation.
Yes, my lord.
No, let us go serially. Okay, page 43 is your reply.
Yes.
Okay. You admitted something.
Admitted and made payments accordingly.
Partly.
Partly.
Okay.
Major issues, major demands I have, proposals I have admitted. Only two.
Then
issues.
what happened?
Thereafter, a final audit report issued, my lord, which
Where it
starts
is?
from
Which one?
page 66, my lord. 66, my lord.
66.
Yes. This is the summary of audit observation.
Audit report. Okay. Right. Thereafter, what happened?
Yes,
That was on
It was on
which date?
August 2022, my lord.
Where is date mentioned?
My lord, the date mentioned in the last page, my lord. Since they are not
Where
issuing
is the
any
date
of the
mentioned?
prescribed form, my lord.
In page
Date-
66. Where is the date?
Page 87, my lord, the date.
No, in
Well,
page 66.
My lord, there is
The
no.
page 88 is part of page 66.
Yes, my lord, that the detailed closure of the detailed audit
Okay, okay.
observation. But since they are not
Okay.
following any statutory
That
prescribed
was
form,
in
my lord.
which date?
My lord, it's signed on
1/9.
1/9/2022, my lord.
Then you replied.
Yes, my lord. I submitted my reply, my lord.
Okay. Then
Thereafter, my lord, in
demand comes to cause.
thereafter in 2020
Under section 73.
73.
Hmm.
Thereafter in 2023, they have issued the demand come to
Let us see your reply.
my reply is at page 103, my lord.
10. There is no whisper.
No, my lord. I'm admitting. Preliminary, I have stated, my lord. I have not in my reply. I have not said, my lord, anything, my lord. Regarding why Shoka's notice has been issued without DRC 01 or it was with the
Oh, what is the provision of DRC?
my lord, under Rule 142, my lord.
142.
Yes, my lord. Rule 142, my lord. May I read Rule 142(1), my lord, and thereafter
Which sub-rule?
sub-rule 1, my
Sub-rule?
lord, for issuing the notice.
Sub-rule?
1, my lord. Sub-rule 1 is for issuing the notice. The proper officials shall serve along with the notice issued under section such and such a summary thereof electronically in form GST TRC 01. The notice has to be issued along with a summary of the notice in form GST TRC 01 and my lord, through common portal only. It has been sent through email.
So tell me, what kind of prejudice has been caused to you?
My lord. My lord. Thereafter, my lord, may I refer page 117, my lord. This is a circular or department instruction is issued by the CBIC directing the authorities.
Now it is an order which is amenable.
My lord. Then, my lord, then second issue is that, my lord, the major demand imposed upon me only on the ground that my the suppliers from whom I have purchased, they have the DSTR 2A is not reflecting those supplies, my lord. My lord, these issues are already been decided in several other courts also, my lord. It has been observed, my lord. May I refer to one judgment only, on one judgment, my lord, in this regard, my lord. And my lord, regarding this non-issuing of the summary of Shoka's notice in DRC 01 and the DRC 07, which is also mandatory, my lord, for issuing the order, my lord. The order issued on 28/12 December 2023. My lord, till March 2024, no DRC 07 summary of order has been issued by the authorities. That is also required, my lord. The rule says that it is a mandatory exercise to be done by the officer, my lord. And accordingly, the board has also issued the.
This is to be taken at the first point of time.
My lord.
Normally.
Yes, my lord. Normally, my lord.
And obviously, ordinarily, it is to be taken at the first point of time. Anything which is required. It is what? Basically, the same thing is to be uploaded in the portal. Sum and substance, in essence,
yes, my lord.
the same thing which is part and parcel of the demand comes to cause notice, it is to be uploaded in a portal.
Yes, my lord. My lord.
Right. Now, question is, it should have been, this point should have been taken at the first point of time.
I do admit, my lord, the Shoka's notice at the time.
Then all this, it is open for you to take all these grounds in appeal.
But
I don't think.
But my lord, today my difficulty is that if today I am going to file appeal against this order, my lord, no DRC 07 has been issued against on the same date. which was supposed to be issued, my lord, along
Take
with
these
this.
grounds in the appeal.
My lord, then my lord, question of pre-deposit and my lord, the recovery
That
is also
cannot be.
is
Now
also
that
taken.
is
No, my lord, I am not on the way of depositing any pre-deposit, my lord. Your lordship can see, my lord, I have already deposited a huge sum of money, my lord. I can also deposit a pre-deposit. I am not
no.
on that
That
way.
is on admission, madam.
Yes, my lord.
That is on admission.
Yes, my lord. This is also a disputed, my lord. I'm not standing in the way of making any pre-deposit, my lord. What I am humbly submitting, my lord, the DRC 07 and the DRC 01 is required to be issued, my lord. My lord, accordingly, my lord,
Required to be issued.
yes,
But
my lord, shall
everything
be.
now, when I am asking, that is that all the decision you want to show
Yes, my lord.
whether this point was taken or not taken.
My lord, after DRC final order,
Because
it has
the
been taken, my lord.
adjudicating authority can decide only those points which were taken in your reply.
My lord, in all these cases, my
It
lord,
can raise all these all these issues before the appellate authority. Now, which you have waived, which you have by implication waived.
no, my lord, I have not.
No,
I am.
why, madam? Your reply. Let us come to your reply.
Yes, my lord.
Where is this?
My lord, even in a belated stage, stage, if the statutory
Now, those
mandate has
can
not
be
been.
taken by appellate authority.
My lord, kindly consider, my lord.
When you have waived, in a sense, by implication, not raising that issue
Yes, my lord.
at the time of making your reply to the demand cum show cause notice. Now, without preferring an appeal, you want to
My lord,
agitate that issue in a writ petition,
no, my lord, not only that, my lord.
226,
My lord, the
which
order.
can very effectively can be addressed by the appellate authority.
My lord, may I, my lord? My lord, the demand order is also not issued along with the DRC 07, which is also a mandatory, my lord. My prayer is also is that, my lord. My lord, may I
Any
defer?
demand cum show cause notice is issued. Show cause notice.
Thereafter, the demand order also has
You
been
are-
issued. That is
your
also not
reply,
followed.
your reply speaks for itself.
My lord, thereafter, the demand order also has been issued with.
Whether these points which you have raised,
I have not raised, my lord.
no, these
very
points
first,
have
my
been
lord, I'm
addressed or
admitting,
not
my
by the adjudicator.
In the before the adjudicating
No,
authority, I have not
in
raised.
paragraph 107, is your reply.
Yes, ma'am.
You have raised something which have been
I have stated, my lord.
adjudicated by the adjudicating
Adjudicating
authority or not.
authority, my lord.
Yeah.
Now, my lord, when the adjudicating authority is
Madam, you
issuing the
prefer
order, my lord,
appeal.
my lord, when the adjudicating authority is issuing the order, my lord, there also he is not following the statutory mandate, my lord.
Every order is challenged, can be challenged in a
My lord, when the authority
this machinery has been set up only for that.
My lord, now, my lord, if today I'm going to file an appeal, my lord, against this, since this order is not in portal, my lord, I will be facing the difficulties, my lord, because, my lord, this is not issued through portal, my lord. It has not been issued through portal. Only a order has been issued, my lord. My lord, kindly, one second, my lord, rule 142.
These are, madam,
five,
these
my-
are two.
My lord, that is why, my lord, that is why I'm submitting, my lord, that is why, my lord, I want to refer these two judgments. There is very recent judgment, my lord. In all these judgments, my lord, it has been considered after the order only, my lord. After
Supreme
issuing-
Court order.
Yes, my lord. after
Supreme
fin-
Court.
No, my lord, Delhi High Court and my lord.
We are not bound by
No, my lord.
Delhi
I'm
High
not
Court or
saying, I'm
Supreme
not
Court.
saying, my lord, but the department has not gone for any further appeal
No,
also, my lord,
as
in
it
these cases.
addressed the issue that a point not raised in the reply to the show cause notice and an order in original has been passed by the adjudicating authority,
Yes, ma'am.
deciding all the points raised in the reply. Can it be agitated in a writ petition without preferring the appeal? Is this the point?
My lord,
Otherwise, no business
my lord, may I
to look
refer?
in.
My
No, no.
lord. That is
I
why,
am
my lord,
asking.
may
A
I?
point not raised in the reply to the demand cum show cause notice
Yes, ma'am.
can be raised in a writ petition.
My lord,
Is this the issue?
No, my lord, I am having another issue, my lord. That is the order of demand, my lord. Order which has been passed, that has also not been followed, the rule, my lord. That also not been followed by the rule, my lord. 142.5, my lord.
Appeal.
My lord, kindly consider 142.5, my lord. Just
Has come down heavily. The apex court has come down heavily.
my lord, kindly consider, my lord, rule. One second, my lord. One second. Rule
That
one-
issue whether addressed or not, my query that a point not raised in the reply to the demand and show cause notice can be raised in a writ petition after passing the order in original by the adjudicating authority.
My lord,
Any High Court has decided that issue?
Yes, my lord, these two High Court had
No, tell me,
decided.
this point is
Yes,
decided.
my lord, because these cases were decided after affidavit, my lord, after exchange of affidavit.
No,
They are-
no. Madam,
My lord, these cases.
my
which I am-
point.
Yes,
my-
my lord.
Please. The authority has issued a demand come show cause notice under section 73. It is a detailed demand come show cause notice, is it not?
Yes, my lord, a detailed
Right.
demand call.
Running into about 10-15 pages, right?
Yes.
Then you have replied to the demand come show cause notice on 4th December. Demand come show cause notice was dated 22nd
9/2023, my lord.
September 2009. So you took full 2 months time to submit a reply and had all the time to ponder about
No, my lord.
all the issues that can be raised.
Yes, my lord.
But you decided not to raise any issue as regards 142. It was not there. By implication,
Yes, my lord.
it appears to have waived it.
But there,
Now, order in original is passed on 14/12.
Yes.
Now, suddenly you have decided that this point, this compliance was not done.
no, my lord.
Whether this point can be taken in appeal or
My lord, that is, my lord.
can be
today I-
taken.
No, my lord, because my lord, why I am submitting, my lord, the order is after 14/12/2023, when the order was issued, that also not followed by the prescription. under
When
the
did you
rule.
receive it? Tell me.
My lord, since it has been received from email, my lord, it has to be on the same date, my lord. I cannot say that I have not received. Since, my lord, the order in original, my lord, since it has been sent through only email, my
So
lord.
what kind of prejudice? What kind of prejudice?
My lord, it has been sent on
One,
December 29,
what kind of
2023.
prejudice? This summary would have been any different from the demand come show cause
My lord,
notice?
it has to be uploaded along.
Tell me,
It has to be uploaded in the common portal. my lord.
No. Tell me the summary which was required
No, my
to be uploaded
No, my lord. It
under
cannot
142 would
It
be
cannot
any
be.
different from
It
what
cannot be, my lord. But my lord, statute requires, my lord, today.
statute requires,
Yes, my lord.
which is for a benefit of a person, right? And waived by the person,
Not only.
waived by implication. He
No, my
cannot be
lord,
released.
if I am not aware that, my lord,
Hey,
if I have
Padmini
not
Sinha.
submitted any objection, my
It
lord.
was for your benefit, right? You have not raised any prejudice. That prejudice is caused because of non-uploading. It was not for other persons to hesitate on the summary statement. It is only you. Is it not?
My lord, pardon, my lord, I could not follow, my lord.
What? Suppose with the uploading of the summary statement in the common portal, who is the person likely to be affected?
Me,
Apart from you, any other?
No, my lord, only
No.
me, my- only me.
No. So the summary statement, is it any different from the demand comes show cause notice?
No, my lord.
Does it require to contain anything more than what is the demand comes
No,
show
my
cause
lord, but
notice?
the limitation.
Don't go to summary as the requirement. Requirement is also to be noted with the conduct of the parties.
My lord, that is what I am submitting. My lord, the date of limitation for filing any appeal
sorry.
is, starts from that day only, my lord. It has to be, my lord. Date of, if it is not being uploaded through portal, my lord. Today, my lord, my difficulty is that today, if I want to calculate my date of filing appeal, from which day it will start, my lord.
That is the issue.
That will be issue, my lord, and that is why, my lord, these kind of forms has been prescribed, my lord. And my lord, that is why the board has specifically issued a circular, my lord, which is binding upon them, my lord. And my lord, there are several other judgments. I need not to mention, my lord, that the circular of a board is binding on the authorities, my lord. And the circular, my lord, which I have annexed at page 117, my lord.
Okay.
Page 117, my lord, this clearly says that, my lord, they are required to issue these notices, my lord. And that
Where is the
circular,
provision for appeal?
my lord,
07, Lord.
107, my lord. Section 107.
Madam, I am not impressed.
My lord,
I am
107
not
is
impressed
required to be
totally.
read with rule 108, my lord. It's required to be read with, my lord, may I refer the rule 108, my lord? That is the procedure for filing of appeal, my lord.
Yes.
My lord, rule 108, my lord, of ESG rule, my lord. That is the procedure for filing appeal.
No, we are only considering your order in original.
Yes.
You have challenged order in original and the so cause notice.
Yes, my lord.
We are not going into the appeal. Appeal provision is there already.
No, my lord, my lord,
We are only testing the legality and validity of the demand
ma'am.
cum show cause notice and the order in original along with your reply.
Yes, my lord, that is
Now,
what-
a mandatory condition can be mandatory when it is now there are exceptions when the mandatory condition is for the benefit of the person in concern and he by implication has waived it and it's no longer mandatory.
my lord, kindly consider, my lord, today if I am going to file an appeal, my lord, I have to follow the procedure of the law, my
That is
lord.
up to you.
That is,
not the concern of the read court.
my lord, that
We
is-
are concerned with the legality and validity of the order that has
Yes,
been
my lord.
challenged.
Yes,
That's
my
all.
lord. My lord, that is, my lord, may I come back on that on issue, my lord? There are other judgments, my lord. Today I am not equipped with the judgment, my lord. There are in Finance Act, my lord, there are Supreme Court judgments wherein it has
No.
been stated, my lord, if any,
Very material provisions cannot be brought in GST now.
no, my lord, but my lord, that has,
See, there are differences, madam. No appeal can be filed. That is the provision.
yes, ma'am.
And in the other act, no appeal can be entered. There are distinctions.
Yes, ma'am.
So one provision cannot be brought in. Here we don't find anything. We prefer appeal.
My lord, kindly consider, my lord, today, if I am going to, my lord, kindly once, just for once, my lord, for my satisfaction only, my lord, I humbly requesting your lordship to kindly go through only once to rule 108, sub rule 3, my lord. My lord, an appeal to the appellate authority under such and such shall be filed along with the relevant documents, either electronic or otherwise, as may be notified by the commissioner. And provisional acknowledgement shall be issued by the appellant to the appellant immediately. Thereafter, my lord, sub-rule
Is
3,
it
my
a
lord.
ground raised in this district?
My lord, since no TRC 07 has been issued, my lord, summary of demand, my lord, that has, these order has never been uploaded in the portal, my lord.
Yes, Mr. But technically,
Whether Lordship for technically can be raised the petition. And where is a specific.
where have you pleaded? Where have you pleaded? All these years.
TRT 10 Lordship 7 or 10 the summary of the proposed notice. Will not in any way prejudice the petitioner.
My lord, paragraph 9, my lord,
And if the notice is
page
lacking
18, my lord.
any information, then there could be a case of that.
My lord,
And they
page
participated,
18.
final order was passed.
There are two authorities, my lord. One authority is issuing the show cause notice, another authority is passing the order.
Very good ground for appeal.
My lord,
Very good ground for appeal.
my lord, even for the merits also, my lord, I have a good ground, my lord. My lord, my only humble submission is that, my lord, since one authority, the authority respondent number 3, my lord, who has issued the show cause notice, now respondent 4 has passed the order, my lord.
Yeah. Delhi High Court says that furnishing of the said summary at the instance stage should be in substantial compliance of the legal provision.
Yes, ma'am.
That does not help you
And my lord, accordingly, it has been set aside for issuing the proper DRC 07
because of your
also,
stand
my
in
lord.
your reply.
But my lord, it has been set aside for issuing the DRC 07 only to that extent, my lord. My lord, may I once again, my lord, that page 89, my lord, the summary demand come show cause notice.
See, madam, the demand come so called notice is to be tested with a reply and the order in origin. It is not that something they have done,
My lord, they have
some
actually not,
procedural aberration,
my lord,
some procedural aberration. That kind of, it is not an illegality, it is an irregularity
my lord, that is,
because no prejudice.
my lord, that,
Because the summary statement required to be uploaded is no different than the demand come so called notice.
my
And
lord,
the receipt of the demand come so called notice has been duly acknowledged by you
my lord,
by submitting the reply
yes,
and without raising anything on that point.
my lord,
Now the order in original has been passed. There is a provision for appeal where you can raise all these issues. they can go into appeal is a continuation of law and fact,
Yes, my lord. the
right?
only
Is a
fact, my lord.
continuation
Yes, my lord.
of the original proceeding, where it can go into law and facts, both. But read, where is the violation of
My
natural
lord,
justice?
two separate authorities has issued, my lord. One authority has issued the notice and another authority has passed the order, my lord. Since it is not being uploaded in the
now-
common portal, my lord.
Now, is it a case that one who has heard has not passed the?
My lord, that is also
No.
accepted.
Have you appeared personally for personal hearing?
My lord, I have submitted a reply, my lord.
Before whom?
My lord, before the authority who has issued the
No,
notice, my lord.
tell me.
Before the authority who
Paragraph
has issued
10,
the notice.
page 110.
One.
Page 110, paragraph 14.
110.
I have said I have not appeared, my lord. I have
One.
submitted the reply, my lord,
Paragraph 14.
regarding personal hearing, my lord.
That's all, madam. Heard.
My lord, kindly
MS?
consider, my lord, kindly consider, my lord, that I have submitted the reply to the authority who has issued the notice, my lord. And now, my lord, the order
No,
has
that is why my specific question was
yes, my lord.
that did you appear before a particular authority who had heard you, and thereafter, to your surprise, you found that another authority has passed the order. Is it a case?
My
No.
lord, that is the
Page
case, my lord.
110.
My lord, that is the case, my lord. My lord, see,
No.
my lord, kindly see, my lord. But it has been issued by the authority if the personal hearing has been issued. If the personal hearing notice has been issued,
It
by
is
the-
also not a requirement.
my lord, that is also a requirement, my lord. That is
You are
under the
mis-
statute itself. That is
Madam.
also under the statute itself, my
Madam,
lord. My lord,
I'm not impressed.
only to that extent, my lord. Today, if I'm going to, I'm not on standing in the way. I bow down by your lordship's observation, my lord. Only the issue is that, my lord, what a statutory requirement or the mandate that has to be followed by the officer, my lord. Otherwise, these
Okay,
kinds of-
we'll observe that.
my lord, who will be the proper
We
officer
observe
in
on
my
that
case?
142. You want to observe on?
Yes,
Make
my
an-
lord. My lord.
We'll
My-
observe.
My lord, the proper officer who is in my case, who is the proper officer and who is the adjudicating authority, my lord. The question today, this
Whether
question is also
this
there, my lord.
authority, one more question.
Yes.
Whether an assistant commissioner has the power, authority, and jurisdiction to pass the order in original or not?
Yes, my lord. My lord, but the same
the
officer,
matter.
my lord, but the same officer who has issued,
Okay, we'll deal with that.
my lord,
We'll deal with that.
my lord, the same officer.
Okay, there are other matters. We'll post it tomorrow motion. We'll deal all with your issues. Mandatory violation of section 142. Secondly, the authority issuing the demand come to proposed notice did not pass the order.
My lord,
Heard? MS?
Shweta Mukherjee.
You be there tomorrow.
No, my lord, I shall not be here tomorrow.
You attend the heard.
I shall appear on Thursday.
Heard. MS. Chatterjee.
Shweta Mukherjee.
Waitam. Learned Council for the petition. MS. Ash Sharma. Learned Council on behalf of Mr. B. Chokra, Central Government Council, for the fund about one. And Mr. S.C. Kyle, learned
Standing counsel for case.
Standing Council, CGST, for the response number 2, 3, and 4. So, third, Government Council for the party is the case. Tomorrow, in a motion.
My lord, I shall appear for
MS. If Mr. Borua, you put a request, the court will permit. Yes, what is the case about?
It is a case, my lord, whatever in 1988, my lord. The petitioner, from the time his father have been occupying a plot of land, my
Mr. Sharma, can it be a bit louder? Louder. Yes.
Since 1966, my lord, the father of the petitioner occupied plot of land covering about 2,800 square feet, about 1 kattha, more or less. And there the house was constructed and they started living there. Father died in 1974, then this petitioner came into to look after the family and the house. My lord, in 1988, a proceeding was initiated under Section 4 of the 1971 Unauthorized Occupants Act 1971, and ultimately an order was passed by the estate officer in 1993. That was SL before the district judge, which is the appellate authority under Section 9 of the Act.
Public premises.
Yes. And that order of the estate officer set aside, and fresh proceeding was to be drawn from the stage of the notice. That order was there by the district judge, additional district judge.
Who is observing?
My lord, annexed, my lord, page 20, page 14. Page 14, penultimate paragraph.
Did not comply with the provisions of Section 4 and 5.
Yes, for the stage of notice, for the stage of Section 4. Then this
Estate
left-
officer did not comply with the provisions
Yes,
of
yes,
Section
yes,
4 and
yes,
Section 5 of the Public Premises
Yes.
Act. Okay.
So that was set
The
aside
court
and
will
my
not
lord,
reveal the appellant had the knowledge of the order and the operation paid by the appellant
Then, my lord,
with the appeal on.
thereafter, my lord,
So,
for
as
about
such,
27
appeal
years, they
period
slept over the
is
matter.
Therefore allowed on notice, order is set aside. It is on the stage of service of notice.
Yes. Then, my lord, for 27 years, there was no proceeding, nothing. Suddenly, 2021 August, my lord, 8th of August, my house was demolished. I the photographs also, and everything was demolished. Not only the house, my lord, TV set, almirahs, cooking utensils, pouring apparel.
That was in 2021.
21.
Hmm.
Then, my lord, we again approached. There was a bit wrong, my lord, legal advice. So, under Section 6 of the Special Relief Act, a case was filed. That was ultimately returned by the trial court, holding that since the against the government, the Section Special Relief Act is not applicable. So, with an observation, ultimately in the that there will be no coercive action taken for a month. That period is, of course, expired month on last 5th. Now, my lord, I am selling the eviction without notice, nothing, without informing me how the proceeding was wrong or not drawn internally, what happened, nothing.
Okay, basically,
But one thing, my lord, before that, my lord,
you are challenging the 2021
yes,
action.
yes. Now, before that, my lord, there is some wrong statement regarding compensation. Compensation, lords will certainly not give. So, that portion of the prayer should be, my lord, foregone now. And
Which part?
My lord?
Which part in the prayer?
Prayer, my lord. Yes, my lord. The page 11. It should be without prejudice. It should be deemed to be not pressed now.
You are not pressing it.
Yes.
So basically, you are challenging the
eviction
action of eviction.
Yes, sir.
Carried out in 2021.
Now notice will go, my lord, let them reply.
Only notice can go at this stage.
Yes, yes.
My lord, the house has been demolished.
That is, I have said.
We have taken over possession of the land.
Clarify that.
Clarify, and also, my lord, what is our demand, my lord? Because just on my attached to my building, my lord, there is a school also. There is, my lord, in the photograph will say.
No, by
anyway, whether that land belongs to railways or the
district judge has found that it is a case for dismissing that or allowing that appeal, but indirectly it has found that it is a case of public demand.
That's true.
Which, because you have not challenged that also. That position remains.
Right.
So only from the stage of Section 4 notice,
yes,
which they did not follow in the year 2021. That is your case.
Yes, yes. And what was my demand was that there should be joint survey whether this land belongs to, because just attached to my house there is a school, my Hindi high school standing there, and there was a case filed by them against me in a civil suit, by which the trial court held that land doesn't belong to the school, it belongs to me. And those things are to be there, my lord. So what we wanted, my lord, what the petition wanted was that let there be joint survey. If the land belongs to the railways, let them take. I have got no objection. Even I would surrender.
Heard, Mr. Kamal and A data. Done. And,
MR Odhikar.
A
MR Odhikar.
MR Odhikar. Central Government Council.
Yes.
My lord.
For the
MR Adhikari means Master of Adhikari office.
for
1 to 5 and 7.
the phone number
1 to 5 and 7.
1 to 5. MSM or managed government. Who is this one number 6?
He has been made party by name.
Oh, where any Melaphide LS?
No.
Where is that?
Response 7, of course, he has been transferred. Let it,
No, where is the clear
let,
statement of Melaphide?
because
Not there.
it is not issuable there. Let his name be stock up. Ultimately, he has been transferred also.
Because to make a
Six,
person,
not 7.
to make an authority as respondent by name, you have to realize Melaphide his name. Where is that?
He can take notice matter 1.
No, which paragraph?
No matter I'm seeking stacking of his name. He can take notice matter 1, 2,
At the
3.
inception,
4,
Mr.
5.
Sharma learned
Senior
has submitted that the name of the respondent number 6 is to be deleted from the area of respondent. The seat there is allowed. So the name of the respondent number 6 is to be deleted from the area of respondent at the risk of the petitioner. But the petitioner.
My lord, he can take notice 1, 2, 3, 4, 5.
No, I have already ordered.
And 7.
Already dictated. The petitioner has alleged that the respondent authority had carried out demolition in the plot of land under his occupation in the year 2021 without following the provisions of law, without following the procedure prescribed in public services.
No, public premises, my lord,
Public
in bracket,
premises, eviction of unauthorized
Occupants Act,
Occupants Act
bracket close.
1971 and the observations made by the learned district judge in Miss Appeal number 8
1994.
in the judgment, an order dated 27/5/1994 passed in Miss Appeal number 8 1993. So, notice regarding government notice. Extra.
Lordship, I record my submission. We have taken possession of the land.
Okay, yes, the recap. Land the development of the railway.
Yes.
The respondent railway authority had already taken possession of the plot of
land.
concerned plot of
A portion of land, my lord. I dispute. Your lordship can submit. I dispute.
the submission
I dispute.
is controverted by Mr. Sharma, by counsel for the petitioner,
And what is their
by
compensation?
submitting that only a portion of the subject land had been taken possession of. Only the position of only a portion of the subject had been possessed by the respondent.
And what is their compensation part that I will not press.
Mr.
without prejudice.
Portal has also submitted that the petitioner is not receiving the prayer as regards compensation as regards prayer for compensation. After you amended cost type.
Without prejudice, my lord.
Ms. Dekha, you file amended cost type as part of
Yes,
notification.
my lord, without prejudice, because I may claim in the civil suit.
Huh?
That I can claim in civil suit.
Okay.
Without prejudice.
In this petition, reserving his right to claim such compensation before the appropriate. That
In this matter, my lord, as Mr. Nath has informed me, as Mr. Nath has informed me, that there is a query from Public Defense Department and Public Defense Department, my lord, and that we have already mitigated that query. And for that, final order has to be, final consideration has to be given by the Public Defense Department. We are just still waiting for their final order. Thereafter, we take 3 weeks.
if something adverse is passed, we will consider it. Because of this circumstance.
I am only regarding family pension.
That is under consideration.
They grant the otherwise conviction.
But only
You don't want to make any
only anxiety.
observation. Let them decide.
Only anxiety is the applicant is in hospital.
We have observed
If
already
it's
in order.
No, that
Previous event,
previous
your
event.
conviction,
Now the condition is more.
and you have enjoyed the benefit. Provisional pension?
No,
It has been
only
stopped. It has
only
been stopped.
I am the wife, widow. My husband enjoyed only for 1 year provisional time.
We have made primary observation.
My lord, regarding provisional family pension,
Once to the issue decided that we delegated it.
it was long pending. That is why I am saying. Otherwise,
Whether
died on 2000.
you are entitled for pension for the period 2000, family pension thereof. Or order has been passed. There are convictions in 2 cases. For one,
One
DP is also against you.
DP against me.
Against you. Conviction
Not
is
me,
also
not-
against you.
Yes, my husband against my.
Sorry, against your husband. I mean, the employee.
Yeah.
And there was no appeal.
No appeal.
And it involves
Financial
misappropriation of,
misappropriation.
which means what is that word? What is that word? Mensia. What is it? Moral turpitude. Apparently, it is a offense involving moral turpitude. It is not that you have hit somebody. It is a case of misappropriation.
It is a case of misappropriation. It is the admitted fact. But so far as family pension is concerned,
For the family pension is entitled. Pension is not entitled. But the
then
family pension will be entitled.
yes,
The family pension,
will be
pension
entitled.
is not entitled. Where is the question of family pension?
No, it may, my lord, come.
If they take a decision, then it is all okay.
It may come.
We will not interfere.
Family pension.
See, family pension flows from what? Pension. Is it not? You are claiming family pension as a widow of the deceased employee. The question will be whether deceased employee was entitled for pension or not.
That part has not been
That is not,
decided.
that is the
That
issue
not been
not
decided.
decided. But if we go on decided on the basis of conviction and DP result,
Now, whether they are now at this stage, whether they can
then court has to pass
take
the
any
order.
decision.
Court has to pass the order. You want it to be decided by this court? Tell me. Option is yours. You can put it tomorrow. Something good can prevail. Government.
I am praying only short date may be given so that government decision can be taken within a short span of time. And if it is goes against me, then their remedy is with me. But suppose
So that is what I am.
but
Base
they-
course is
they are
for you.
they are keeping matter in tight for last.
That is what
Immediately after filing,
we are concerned with. So why don't you pass the order?
and
Everything
order,
is
order
available.
has been passed also by this court. There is an order, madam.
Which order?
There is an order on.
Oh, that was prior to your conviction.
No. Now during this pendency of this case.
Which one?
Last order, madam. Final decision for taking final decision. Six two. Order dated 6/2/24, madam.
6/2/2024.
2024.
20.
No, Tara court.
No.
No, before that.
No. 8/1/2024. The respondent number 1 and 2 may in the meantime proceed to take a final view in the
Yes.
matter in transfer of provisions of the Assam Services Pension Bill 1969.
Yes.
So that has not been. Please take a decision.
Fine. Do it.
That is
Mr. S.K. Ghosh, Learned Counsel for the petition. M. Bormon, Learned New Government for the respondent number 1 and 2. Mr. H.K. Das, Learned Standing of the case for the respondent number 3, 4 and 6. And Mr. P. Borua, Learned Standing of the Counsel General A&E for the M.S. Bormon, Learned Junior Government for further time to obtain instruction in deference to the order dated 8/1/2020 as to whether any final order has been passed or not in the matter. Final order. The prayer made by Mr. Bormon is accepted.
After the
no.
Third of June.
Okay.
7 to 7.
it.
28, 5 lakhs. 28. Wait.
Mr. Borua.
NN Datta.
NN Datta. And wait, and fine. And thought for my friend is the case of 85,000. Dr. Saab has completed his submission or
Yes, sir, Dr. Yes.
submitted?
Item 18.
Sorry, we have put the applicable, but we are yet to receive instruction seeking some of them.
NN Doctor for the petition. And Mr. B. Chaudhary.
Correspondent.
For the
2, 3, 4, and 5.
who is one?
One of the
H. Sharma. And He should be number 3, 4, and 5. Mr. R. A. Accountant, principal accountant, has report. And it's not by conservative respondents.
Lordship, there is an interim of,
But the affidavit of the AG
Obliged.
also will be.
Huh? Okay. Both.
obliged.
Mr. Sharma. Sorry, Forest. Forest. Mr. Sharma, retribution was preferred, is preferred. Conservative is in 5.
Item 19, Lord.
You are not a party person.
We are not a party.
Now, the Learned Council, who represented the petitioner, filed an affidavit to warn
By them.
herself that
They are withdrawing.
the colonization is withdrawn. Now, that is on 17 August 2018. What to do? Petitioner has not
A notice to
engaged by if that is a registered post, letter was sent
to the petitioner.
to the petitioner.
It was received by.
Received, I don't know. Only postal receipt is sent. What to do?
Lordship, let the matter be kept pending for some more days, Lordship. I will inform them that Thakuria, NS Thakuria.
So, he has filed the affidavit.
Yes, Lordship, but they should be present here, Lordship. And
On the previous day, he was present.
Lordship, I appear for forest department.
How to deal with this situation?
Lordship, we have not received instruction about them withdrawing.
Third, Mr. Ibot has started sending up environment forest department for the response number 4, 5, 6, 7, 8, 4, 9. Any central government council?
If it is registered 80, then that 30 days presumption.
What should we draw? What is the requirement for this code? The learned council who used to represent the petition has submitted a sworn affidavit dated 17/8/2020 stating that the petitioner did not petitioner was not petitioned on several occasions. Calls were made to the petition for the purpose of filing additional affidavit. But the petitioner did not respond to such calls, and finally, on 24/7/2023, a letter asking the petitioner to visit the chamber of the learned engaged council on or before 2020 was sent by registered post. On 26/7/2023, as the petitioner did not make any contact either through or by visit, the learned and has withdrawn the Ukala today. None has appeared for the petition on call. It does transfer that the petition has not made any alternative arrangement to represent his case till date. The above any question? Case, for instance, it is again on the 2/5 in the event and appeared on behalf of the petition on the next day, the court may consider appropriate.
In item 20, Lordship, we have been directed to obtain certain instructions, Lordship. So we have sent the letter, but we have not received any instruction. That's what I-
Yes, anything from your side?
No, yes, I have not. Issue is simple, Your Lordship.
Issue is simple. Have you obtained any instruction after
No,
the
yes, no.
previous date of listing?
No, I
Huh? Are you contacting with your client or?
client yet. I
Then
have
we
not
get the information.
Whether it was
Whether you have been facilitated to take out your personal belongings.
not facilitated.
You said you are not in contact, you don't know. You are in contact, but you don't know the present position.
Few days back.
So why you are waiting for Mr. Sharma to take? Last order was passed on 1st of February 2023.
After that,
We are in May 2024.
last week we have contact.
What did he say?
It is not allowed.
Huh?
Not allowed. Not allowed to bring.
Are you sure?
Not sure.
Sure. But if I find after instruction from Mr. Sharma, then it will be a wrong submission. You take the risk. You take the risk.
Last week I have.
Because he is a member of government service. If he makes wrong submission, otherwise it will be pending unnecessary. I will record. Heard Mr. F. Standing counsel for the petitioner. Yes, who is standing counsel? Health.
Health.
And Mr. H. Sharma, learned additional
Respond
senior
number
government advocate for respond number 4. Post of Mr. Islam, learned counsel for the petitioner, has submitted, instruction, that the petitioner has not been allowed to take out his personal belongings, from the office chamber of the police hospital, Dibrugarh, till date. Mr. Sharma, done it. I think health is required. Health council is required because it is hospital.
P. Gogoi Lordship, we can accept. He was
So let him be there. Here. Otherwise, if it turns out to be wrong, I'll impose a big. One cannot be taken for a this court cannot be taken for a right. And somebody private counsel also appeared.
Yes, sir.
Yes. What is your case? What is your present position? Everybody is waiting for last 1 year. Okay. You are serving as what? Mr. Vidas. Okay. Vidas. Number 5.
Question number 5.
No, for this small matter, one repetition is pending for last 1 year. It is unnecessary. Mr. Das, learned counsel appearing for the response number 5. Who is the incumbent medical and health officer at the police hospital, Dibrugarh, has submitted, instruction, that the petitioner has never approached the response number 5 to take out his personal belongings from the office chamber at the police hospital, Dibrugarh. So you want to get it facilitated to court?
Because that it is locked here. Earlier it was.
Where is the health? He is saying he has not been given. You say he has not approached. This is unnecessarily pending. Absolutely.
Earlier one
For
order,
1 year, nobody is taking instruction.
earlier one order was by this court, and as per this order, he was allowed to to take his belongings from his quarter, but this office chamber, it was not allowed. I have annexed this order also, page 23. After this order, he was allowed to take out his belongings from his chamber, quarter, your lordship, official quarter, but his office chamber, some belonging is there, it was not allowed.
Where you are posted now?
Presently, I am posted at Lahwal, your lordship, sub-division medical.
Lahore. Then you approach Mr. Das. You facilitate. You appear. You appear before the medical and health officer. The police hospital, Dibrugarh, on a fixed date. You facilitate whatever. The Mr. Das's partner submitted that if the petitioner makes a visit to the police hospital, Dibrugarh, on a fixed date, comma, the respondent number 5 would facilitate the process of handing over the personal belongings of the petitioner, comma, if any, in the office chamber of the medical and health officer, police hospital, Dibrugarh. Okay. When Mr. Islam, counsel
Next
for the
week, any date.
petitioner, has submitted that since the petitioner is presently posted at Lahwal, comma, the petitioner will appear, will make a visit to the office of the medical and health officer, police hospital, police hospital, Dibrugarh, at 10:30 a.m. on. Yes.
Next week, any date.
On 13, 5, 2020. Please the case on 75, 2024 for the learned counsel for the parties to place instruction, further instruction. MS. I that. Learned training counsel. That's one number one. Learned training counsel. Not necessary to keep this pending.
Yes, Lord.
Third, in pursuant to your lordship query, the state had filed an affidavit on the last day. My lord will recollect your lordship had directed the state to indicate as to who is the competent authority to grant sanction. They filed the affidavit on the last day. We need some time to respond to it.
Lordship, the affidavit may kindly be seen first. Whether any stand of the private respondent is required, then the time may be given. Because the government says no permission is required. And in the name of permission, last 3.5 years, they have made the entire cover up. Point number 3. Page number 169.
169, yes.
Point number 3. May I read, sir?
The opinion of the judicial department and the legislative department are found at variance.
The political department's stand is every time changing. In 2019, they have written.
No, they have referred to certain decision of the Supreme Court. Narasimha Rao
And Dilip Kumar Saikia.
You have to go by that, not by the views of the legislative department or judicial. Ultimately, yes, we have to go by that. Yes, but
First thing, my lord, this opinion is flawed in the sense. First of all, they referred to a judgment of the Punjab and Haryana High Court, Surinder Kumar Bansal, and they said that it is not required for retired public servants. First of all, the judgment is not of the Supreme Court, number one. Second thing, my lord, after this judgment of Surinder Kumar Bansal, the provisions had undergone an amendment, whereby retired employees were also, public servants were also extended benefits, extended their benefits. In fact, that was something which was taken note in Surinder Kumar Bansal. That is part of the record at 117 if your lordship sees that judgment. Alert, an amendment was introduced to 197 and Surinder Kumar Bansal said that since the corresponding amendment is not there in 19, so ex-public
which page?
Page 117 was part of their affidavit.
It's 70.
170. This is affidavit filed by the writ petitioner on 111. Part of that.
Actually, this stand is taken by the government in its order itself, where they denied that there is no permission is required. Therefore, the
Part of the affidavit filed on 111.
170. Punjab and Haryana.
This is a Punjab and Haryana High Court judgment. Now, if your lordship turns to para 6 at page 120. I may read. Section 19 of the PC provides that no court shall take cognizance of an offence punishable under 710, 11, 13, and 15 alleged to have been committed by a public servant except with the previous sanction of the appropriate government. The sanction contemplated in section 19 of the PC is mandatory if the accused public servant continues to be a public servant when the court takes cognizance of the offence. But if he ceases to be a public servant by that time, the court can take cognizance of the offence without such sanction. The protection provided under Section 19 of the PC Act is not available in case of a retired public servant, whereas Section 197 of the Code, it is mandatory to obtain sanction for prosecution of a public servant for the alleged offence. If the same was committed by him while acting or purporting to act in discharge of his official duty, even in the case of public servant, the necessity for previous sanction under 197 of the Code is made applicable to a retired public servant by using the words when any person who is or was a public servant. No such language has been used in Section 19 of the PC Act. Thus, keeping in view the language of Section 19 of the PC Act, it is clear that no previous sanction is necessary for prosecution of public servants for offences alleged to have been committed under the PC Act if such a public servant ceases to be a public servant at the time of taking cognizance by the court. Now, the question for consideration is whether the additional sanction under Section 197 of the Code is also required for prosecution of a retired public servant if the alleged offense is under the PC Act, for which offense no sanction under Section 19 of the PC Act is necessary. In my opinion, this question has been answered by the Honorable Apex Court in Fluence. Now, that is quoted. Here, my lord, the Supreme Court says it must be remembered that in spite of bringing a significant change in Section 197 of the Code in 1973, Parliament was circumspect enough not to change the wording of Section 19, which deals with sanction. The reason is obvious. The sanction contemplated in Section 197 of the Code concerns a public servant who is accused of any offense alleged to have been committed by him while acting or purporting to act in discharge of his official duty. Whereas the offences contemplated in the PC Act are those which cannot be treated as acts either directly or even purportedly done in discharge of its official duty. Parliament must have desired to maintain the distinction, and hence the wordings in the corresponding provision in the former PC Act was materially imported in the new PC Act of 1988 without any change in spite of the change made in Section 197. Now, that corresponding change was later introduced in 2014 in the Act. This was the reason why the Punjab and Haryana High Court basically held that though 197 was amended, a corresponding change was not done in the PC Act. And this was rendered in 2006. And thereafter in 2018, my lord, 14, (19)(a) was amended.
17A.
19A and both were amended.
In
2018. That is footnote 4, if your lordship. Who is employed or, as the case may be, was at the time of commission of the offence. 18. Section 19, 1A and B also. Could be prospective one. But prospective, even if it is prospective, my lord, then also, my lord, today the phase of sanction has not arrived. So therefore,
Lordship,
this will call for a consideration if I'm given a chance to respond.
Lordship, this is not the matter of Section 19 or 197 CRPC. This is the matter of Section 17A of PC Act. Section 17A of the PC Act does not apply to disproportionate asset cases. This is an unnecessary letter was issued on 13/1/2021. Because of that letter, every goof-up has been created in last 3.5 years. This is an absolute order of the Madurai bench of Madras High Court, where in the year 2021,
What is the delay? In fact, that is what I wanted to point out. Page 17 of the repetition, it was never their case that sanction is not required. In fact, there was a prayer mandamus thought that please accord or refuse sanction. Now there's been a paradigm shift saying that sanction was not even required at the first. Page 17 is the prayer, my lord. Yes, therefore, uh, the approval was record. Approval was denied. Denied. That was brought on record by the state respondents in their affidavit. Page 48. Page 48. Probably
48, sir.
Is respond number 2.
yes. So filed
Now,
along
it
with
is nowhere written that respondent number 2 has denied. It has been written, it has been denied by the competent authority. So the matter of competent authority arises in the matter of XMLA. And the lordship has asked who is the competent.
Is it under selling?
Yes, sir.
This is not under.
Is this order? Is
Lordship, this
is
order
under-
is void already. I have filed an
Why do you
affidavit.
do? Making some, whether it is under challenge. An order which is not challenge is not to be gone in.
Lordship, it is
No,
your
I'm
lordship,
asking-
yours, means
No,
let
Miss-
an
no.
order issued by an authority who is not
petitioner
competent to do so.
No, Mr. First, I have asked you a query.
Sir,
Firstly,
I have.
it can be answered either by yes or no,
Okay, right, sir.
without any kind of explanation.
Okay,
Right?
I have filed a detailed affidavit.
Whether this order at page 48 is under challenge or not.
Yes, I have challenged it by way of an affidavit. I have filed an affidavit in opposition, disclosing how this order is illegal.
How this order is illegal.
Illegal. I have challenged the
Yes, what is the
illegality
law?
of the order.
And whether by way of an affidavit in opposition or additional affidavit, an order can be challenged.
So there has to be a specific prayer, my lord. It could be wrong, it could be bad in law, my lord, but unless there's a direct challenge. Because now I will be taken by surprise in the sense, Lord,
Lordship, there is a circular which has been enclosed by me in the writ petition itself. This circular is by Central Vigilance Commission on the basis.
There is a fact-finding report. It has referred to 25/2020. That person, respondent number 5, or what? You want prosecution against him under what provision? Under what offense? For what offense?
Disproportionate assets.
Disproportionate.
My complaint is at page number 21.
What connection you have shown? What connection you have shown that these properties were acquired?
Actually, we have tallied with the election affidavit of 2016 filed by Dr. Samua. And when we match out the election affidavits and the properties sale deeds which we have received from our sources, it has been found that many of the properties are not been listed in this election affidavit. Relying upon this, that the election affidavit has been filed in accordance with the law, disclosing entire properties which is mandated in the Representation of People's Act, we have complained it to the Director Vigilance and Anti-Corruption through email. Director Vigilance and Anti-Corruption responded back, said that please sign and submit formally a complaint letter to us. Then after we can only take action. And accordingly, we have filed the complaint. After filing of our complaint, the department took cognizance and write a letter to the government on 13 December 2018, seeking approval for regular inquiry. This annexure 2 is the communication of the regular inquiry order. When I asked the authority, who is the competent authority to give the approval in this matter, they responded that it is the Chief Minister of Assam is the competent authority. Today on 25/4/2024 affidavit, after 5 years, they are saying that it is the Speaker of the Assembly. So entire goof-ups has been created by the state.
Oh, first I want to know the basic thing. That you made a complaint that this man has MS asset is proportionate to his known sources of income.
Yes, sir.
Now, making an allegation that he was a close confidant of a minister.
Yes. Because there are lots of newspaper readings that
Newspaper don't say hearsay.
No,
Don't
sir.
bring
Let-
hearsay.
let-
I have
let me-
already
let
heard.
me complete, sir. Let me
No,
complete.
Mr. Newspaper report is considered
In
and treated to be hearsay.
Yes, sir.
Right? I don't consider that as an evidence.
Okay.
Don't make a submission because this court has already held.
Okay.
Right? Newspaper report, don't bring it. Media report, don't bring it.
Okay.
Right? Now,
So the annexure 20, page number
you have made an
25, annexure
allegation
three.
of amassing disproportionate
Yes.
property to his known sources.
Relying upon the election affidavit, comparing with the elections affidavit.
Now, whether how this has come to case of corruption,
So because the properties were purchased when he was the member of Assam Legislative Assembly.
how you have established a link
Yes, I have submitted the sale deed, copy of the sale deed to the agency.
That is corruption.
So the properties has not been disclosed. Properties has been purchased in the name of wife and minor daughters at the time when he was the MLA.
So there is suppression of material fact. Those are suppression of material fact. He has not made full disclosure in his affidavit.
Now, he has not said this in his affidavit. He has filed an affidavit
Right.
in this court. He has
Suppression.
never told that he has suppression of the facts.
Suppression of fact regarding property in the affidavit. Right.
No, sir, this is not the suppression of the facts. What happens? There is a scandal happened in Assam Social Welfare Department amounting to.
We are not investigating agency. You are not the investigating agency. Please respond to my question.
Sir.
You have made allegation in the complaint made to him that he has made something, that these are his property.
Yes.
Right?
Yeah.
And it was not disclosed in the election act.
Yes.
That is the sum and substance.
Yes.
And you made a prayer for making an investigation.
Yes. That's
now, first issue is non-disclosure of the property, movable or immovable, in the election affidavit. Right? What is the conflict?
no, I am not complained under representation of People's Act. I have relied that he has disclosed his legitimate income in the affidavit and the illegitimate income he has not disclosed in the election
How do
affidavit.
you say that it is gathered?
No, no, that is what I have said, sir.
From
Sir,
what is the lead?
This to establish this, we have
What is
also
the affidavit of the regular inquiry report as regards the
Sir,
regular
nobody knows what is the date of regular inquiry report. If nobody knows today, I am since last 2.5 years, I am asking the regular inquiry report. Nobody is asking. Nobody is giving. I have also made an IA just to provide the copy of the regular inquiry report. Everything has been kept in the red carpet because
I have seen it. That is what, there is no challenge. Rightly or wrongly, he has made a prayer, and rightly and wrongly or wrongly, order has been passed.
I have not wrongly, sir. I have relied upon the government's information that the chief minister is the competent authority. Today they are changing their stand. It is in writing. They are submitted even the copy of the file movement. Nowhere it has been seen that the file has been sent to the speaker. It has been sent to the chief minister. Chief minister accorded the approval, and accordingly inquiry completed. Inquiry report has been submitted. Inquiry report says that the 2 crore 16 lakhs was the disproportionate assets, and the prayer was made as per the readings. It is under section 17A. So disproportionate assets matter does not cover the section 17A. There is no approval required under section 17A. This is a vogue letter. Because of this letter, every confusion has been created, and this letter was issued when the matter was pending before this court. That is the seriousness of this case.
Let me go to it. Everybody is making diverse submissions. I was out of the bench also. So we have found those are at variance to each other. So he needs a sanction or approval. And your legislative and judicial department says that no approval is required. Then what is live?
Then the
What is
reply
live
of the
then?
respondent number
Mr. Dekka?
My lord, the only thing is, my lord, even if it's the
He asked for an approval, direction to grant it. Mr. Nath is saying no approval is required. Then what is the live issue?
the live issue is the prayer number 2. So live issue is the prayer number 2, the delay.
the delay will come.
The delay is there because 3 years has been passed. Honorable Supreme Court and the legislative intent is that the decision has to be taken in 3 months. And the decision has been taken when the court has placed it. So
You
the
have raised an issue that the approval is required, please grant approval.
Yes.
Now state has come up which has said that no approval is required. Then where is the question of prayer?
State is not come up with that the no approval is required. State says that they denied the approval. So the no approval is required and the denied the approval is totally different statements of the state. That is the problem. That is the problem of the state. Because they are changing their statement again and again.
For you? Ina.
Thank you.
Let me go through entire paper. Monday. Good.
Matter, the pleadings are complete. Last effective order is 24/11 to 23, wherein our challenge was restricting our stoppages. We are a bus owners association in the Dibrugarh town. We are permitted to fly to the town, but no stoppages was given. We in our grounds we say that this is in violation of the earlier court's order on the same issue. There was an amicable settlement in the trial court that is also violative, and moreover, the whole area is covered by statutory under Motor Vehicle 2003. So there is no scope for issuing any executive order in this regard. Regarding the jurisdictional point, they have remained silent. Other things, they say that they can put reasonable restriction. Another point we have raised, that reasonable restriction can be put only by a law. It cannot be done by executive instruction. Therefore, that also they have not.
Yes, I mean, Bora.
Lordship, here Deputy Commissioner is the main respondent and they have filed affidavit. I have filed affidavit. He took the formal party. But last occasion, this honorable court has directed the instruction
Regarding 24/11 that I have showed.
I have written
on affidavit so that we can.
Sure.
Because question of public confidence vis-a-vis the interest of the past owner
Yes.
are at
Yes. So, Lordship, earlier there were 5 stoppages. Now we have, during the course of hearing, we also stated the traffic system was not like before. So we are agreeable to 1 or 2 stoppages, but absolutely not giving stoppages is not even suitable for the customers also, passengers also. So
let them place
Lordship, this is
along
the
with
map
that,
of the Tipperary.
because public convenience and traffic condition, road conditions, interest of the past owners are all to be considered. But present day situation is not like 10 years earlier.
Lord,
That is also an unplanned city like Guwahati.
my lord, may direct the government to get to place on record because I have resigned from the government yet in month of March and the
Sir.
festival has
And if this place it,
I
they
will
have
provide-
suggested few things. You respond, right? They have suggested that buses can be stopped here and there.
oh, one good stoppage, 1 or 2 good stoppages is
You
okay.
find out whether feasibility is there or not.
Yes, yes.
For your, at least, there may be cut in your profit margin, but if there is profit margin available, hurt, then we can place it both at both your end. But Mr. B.P. Boda, Planet Council for the petition. You are there, then transport.
my lord.
Okay. MSMD Boda, Planet Standing Council Transport Department for the number 1 and 3.
Lordship,
And Mr. K.N.D. Planet Junior Mr. M.S. Boda and Mr. Handy have submitted that pursuant to the order dated 24/11/2020, comma, the instructions have been obtained as regards stoppages near Dibrugarh University from the district commissioner from the respond number 2. You have a map also,
map. Yes.
distance map,
We have already produced this map before its honorable court.
and a distance map. And the same such instructions will be brought by way of an affidavit. What time?
We have deputy commissioner
1 week? 10 days? 2 weeks? Okay. In order to file the said affidavit, additional affidavit. Additional affidavit. From a 2 weeks time have been paid for. The prayer for filing the additional affidavit. Within 2 weeks, it allowed the case.
Lordship, since there is no interim order, Lordship, may give a date.
2 weeks.
deeply. Mother, may I get obliged.
I don't do it. No, it is not kept. Already returned.
Obliged, madam.
The beneficiaries, my lord, they are entitled to get the PMAYG houses, but initially they are not.
Yes.
Well, the petitioners are the beneficiaries of PMAYG houses, my lord. There belongs to the Tupamari and Rangabani village areas, my lord.
So
They were
their names are listed in the
listed,
beneficiary list,
my lord,
but houses are not.
not given, my lord.
That is your case.
They are well, only because of that they are said that they are migrated from other place. But Aadhaar card, Gambura certificate, census report all reveals that they are belongs to Tupamari and Rongeshwari. Rongeshwari. Tupamari and
So you are seeking
Rangapara.
PMAYG houses.
My lord.
Lordship, we have received the instruction, your Lordship. Subjects may be even file our affidavit.
What does it say?
We have forwarded his name, sir. There are 4-5 petitioners, sir. We have forwarded an instruction.
Their name are in the list of beneficiaries or not?
Lordship.
Their name are included.
Lordship.
Okay, then it is in your favor. Let them file the affidavit. Heard Mr. B. Islam. 12 MS
J. Bora, Lordship, on behalf of S.
J. Bora,
Sir. On behalf
Learned
of S.
Council,
On behalf of S. Dr.
representing Mr. S. Dr. Lawrence, Pending Council, Panchayat and Rural Development Department for the phone number,
3, 4, 5, 6, 9, 10, and 30. Sir.
and Mr. J. Henry, for the phone number 2, 7, and 8, and Mr. M. I. Singh, for the council for the phone number 12, 14, and 15. MS Bora, Learning Council, representing the respondent authorities in the Panchayat and Rural Development Department have submitted that necessary instructions have been received and affidavit opposition will be filed within
2 weeks time maybe.
2 weeks time. So, Ms. Bora has asked for the prayer for filing affidavit of such affidavit opposition is allowed within 2 weeks is allowed.
I'm obliged.
Item 24.
My lord, may be allowed to correct one village, my lord. All the petitioners in copy paste, it is revealed that village Tupamari, but petition number 3, 4, and 5, they are belongs to village Uttor Rangabani. my lord.
You have to file amended cross title.
Mm,
We cannot allow correction.
After correction of the petition, we have filed
No, it is not yet corrected.
because Hero's name is what?
It is not yet corrected.
Yes.
It has to be corrected by filing amended cross title or by filing appropriate application. None has appeared for the parties on call. So on the previous date of booking, comma, that is on 17/10/2000, comma, none had appeared. None had appeared on that. Of such on behalf of the members.
This is against non-payment of contractual dues. As per the last occasion, Honorable Court has directed the authority to process the proposal.
If this matter can be disposed of in the line of non-federalism, the demand has been submitted by the executive engineer to the engineer. But
What
is this about? House rent or what?
No, my lord, I was entrusted to construct certain irrigation canals. Now, there was a flood, it got damaged, got carried away also some parts of the project after I completed it. And there was a dispute. And it was.
Any affidavit from your side?
Lordship, no.
Then how can council?
Lordship, I give 2 weeks time.
Something you admit, then we can dispose of.
The only thing I have got, Lordship, is the demand submitted by the executive committee.
On that basis, you can do it. File the affidavit.
Lord.
Then we can direct the
Lord.
Or Mr. P. Bharadwaj and council by the time. But for all the I just have paid for and thank by affidavit. That's what so, yeah.
Lord.
Item 27.
May I please, Lordship? The petitioner counsel could not appear today, my lord. His relative family members expiring today.
What happened?
His family members expiring today.
Where?
Yes, my lord.
Mr.
Tipego.
Tipego. There are two names. Whose family member?
Surajit Das.
Huh?
S. Das. Mr. S. Das.
Learning Council appearing on behalf of Mr. That's didn't believe me. Well, the paper. 2 weeks?
2 weeks.
Okay. Turn it. Affidavit is filed already. Affidavit has been filed. Either email. Yamamoto, you're there. Yamamoto. And you of them down or
Item 29.
Lordship, we have received that matter with 5 minutes.
Matter pertains to eviction of some persons in from 3 villages in Karimganj.
Mr. as they and for the petitioners and Mr. BJ. Learn. Give me PR Mohan, Revenue President Mr. Olivia has submitted that necessary instructions have been received to file counter affidavit and the counter affidavit filed in 3 weeks. Yes, that's all. Made on behalf file.
May it please, Your Lordship. This case, Lordship, regarding revised rent of the house utilized by the PW department, Lordship, they have already filed their affidavit in opposition.
House rent.
Yes.
House
Lordship.
rent.
Yes, Lordship. By respondent number 5, affidavit in opposition they have filed, Lord. Maybe it is on record. In para 5, they have admitted that regarding refixation of rent, some correspondence have been made to the executive engineer PWD within Silchar by letter number 2 dated 30/10/2020.
Who has filed the affidavit?
Respondent number 5.
Who is it? Executive engineer.
Executive engineer PWD Silchar building.
Paragraph 5, sub-para.
Yes, sir. And thereafter, Lord,
Now, some correspondences have been made to the executive engineer, PWD.
Lord, that
He is the same person.
yes, Lord, in the
Where
year
where is this annexure 3?
that is of Lord, in the year 2020, annexure
The
to page
executive
41.
engineer. PWD building division. He is Shaktipuur civil. No, for what period you need
Lord,
the rent?
para 13 of my writ petition, Lord. Page 10. Start from page 10 to page 11.
So during for what period? From October
Yes. October
2015.
Yes. To 2019, Lordship. An amount of 3,45,000 they have paid, but enhanced rate, that rate was not accessed by the department. But for that,
So fixation has been done or not?
no,
If I-
Lordship, enhanced rate they have not done.
Yes, Deputy Commissioner. Huh?
Lordship, the earlier order, it was direction given to the circle officer.
They have been made a party, Deputy Commissioner. Because according to you itself, I think paragraph
Page 27, Your Lordship, that order passed by this court in earlier. Page 30, para 7, there the direction.
Effectively, it is secondary petition on the same.
Lordship.
No contempt was filed. Then no purpose again. There is a direction. Where?
My lord, the first case, the file it with the page 27.
Thereafter, Lordship, we informed him, Lordship, and
So they have to make a party on that, my lord. Dispute.
Where? Here it is. He made a
20,
party.
no, Lordship, my lord, the page 27, annexure 7. Lord.
Right. It was not made a party.
Lord.
But there was a
Direction
direction.
was given to the, my lord.
Don't
And
go into those technicalities.
and in the
It is an admitted
Even-
fact that
even the Lordship, my lord,
PWD was in occupation of that house. Circle officer has been directed. Now, just because he was not a party in the earlier decision, now he has been made a party.
Lord, my lord, that,
we have informed, Lord.
He now here you have accepted notice.
Lord, that is true, Lord. We have accepted the notice.
So then, please respond to it. How whether you have done it or not.
Sometime we going, I have to obtain instruction. What they have done.
Because it is simple. Everything was there. Earlier assessment was there. Only you have to revise it. As per after looking at the zonal valuation. That's all.
Let me take
it is not that new thing is to be assessed. Already assessed. Now every 5 years, new rate. What is the area of the land? What is the size of the house? All are available.
Page 21, Lord.
Earlier assessment order is available.
Page 21, Lord.
Page 21. What is the role to be played by the circle officer?
Lord, he will reassess the amount, Lord.
No, he will not reassess. Reassessment of rent will be done by the PWD.
PWD only.
But it is the valuation of the land.
Lord. Not that. So, Lordship, in affidavit in opposition in paragraph 7, they have admitted that
So
as
come to page 7.
annexure 3.
This is what is required from the circle. Valuation of the land. Thereafter, PWD will assess the rent on the basis of zonal value.
For that, Lordship, the process was initiated in the year 2020.
Mr. Hendrik,
Lordship.
we can do one thing that petitioner will submit an application along with a copy of this annexure 3 within 1 week before the circle officer. On the basis of that, the circle officer will provide the instruction to the executive engineer regarding the zonal valuation of the land, so that the executive engineer can revise the rent. Then after we'll fix the case after 2 to 3 weeks.
And in paragraph 7 also, Lordship, they have admitted that respondent number 5 that they will pay the revised rent.
No,
from the
firstly, the rent is to be fixed.
Sorry.
One is zonal valuation of the land. On that basis, the executive engineer will fix the rent. Let us expedite the process. Instruction will take time. Hard. MS R. Chaudhary, Learned Counsel for the petitioner. PWD. Mr. H. Burua, Learned Counsel. Representing Mr. D. Chaudhary, Standing Counsel. Oblique Court, Perfect for the husband of 1, 2, 3, 4, and 5. And Mr. J. Hendy, Learned Hotel. It is the case of the petitioner that he is the owner of an Assam type building, which stands on a plot of land measuring 4 kapha 4 kapha, covered by tract number T3 and Patian number 303, situated at ward number 1, Karimganj, district Karimganj, Karimganj town. Subject for the Assam type building was taken, it was still in possession. No, Lord. The Assam type house, along with standing on the subject plot, was taken on rent by the respondent Public Works Department to run the office of the Assistant Executive Engineer, EWD, AATP subdivision, Karimganj. Since the WEF 1/11/2005, on the condition that monthly rent would be assessed and fixed by the PWD building division as per the procedure prescribed by the government. It is the further case of the petitioner that the parent is to be revised every 5 years. And in such view, the matter, the rent for the Assam type house building, Assam type house, was to be revised in the year 2015. Right?
31/10.
Is to be revised with effect from 31/10/2015
November 2000,
till November
2019.
2019 as the respondent PWD department, PWD authority had vacated the same on 30/11/2019. 31 or 30 or 30/11, 30/11. With the appropriate possession, the petition. Petitioner has preferred the petition, seeking a direct to the respondent PWD authorities to pay the rent for the period from November 2015 to November 2019 at the revised rate. The petitioner has stated that an amount of rupees 3,70,608 had already been disbursed towards house rent for the period to him, towards house rent for the period from 1/4/2015 to 30/11/2019. That is for 56 months at rupees 6,618, which was pre-revised rate, right? Pre-revised rate. 6,618 is pre-revised.
Yes.
The petitioner had earlier approached the court by the petition, WPC number 1318/2020, and the said petition was disposed of by an order dated 22/06/2022. Inter alia with a direction to the Circle Officer Karimganj to furnish details like revised valuation in respect of the subject dot to the PWD authorities, respondent PWD authorities, so as to arrive at a revised rate of rent. So it is relevant to mention that earlier, earlier in the year 2006, the house rent was assessed and fixed on the basis of the zonal valuation of land, provided by the Office of the Deputy Commissioner, Karimganj, by this to the Executive Engineer, PWD, Silchar Building Division, by this letter bearing number A7. Having regard to the issue involved in this petition raised in this petition, it appears appropriate the petition shall approach the respondent number 6 with an application seeking fixation of revised valuation of the subject land within a period of 1 week from today, along with the letter bearing number, along with a copy of the letter bearing number. The respondent number 6, Mr. Hendik Lanet, Junior Government has appearing for a number has submitted that on receipt of such application, the respondent number 6 will make endeavor to provide the revised valuation in respect of the subject land to the Executive Engineer, PWD, Silchar Building Division. Respondent number
5.
5.
He has filed the affidavit in opposition.
Within a period of 2 weeks from the date of receipt of such application. 1 week he will submit. Election. Election. Okay, counting.
Well, they are the officers
right here. Take it 4 weeks. After 6 weeks, on which date and Mr. Borua shall pay tax as regard the matter of fixation of right house. Correctly.
In this matter, I appear. In this matter, notice was issued way back on 15/12/2023, Lordship, where the respondent authorities were supposed to bring on affidavit. They stand regarding whether the 50 feet reserve land falls within 18 feet or not, Lordship. But since then, Lordship, there's been no progress in the matter, and since our business establishment have already been demolished, Lordship, so we are facing penury.
Lordship, I am appearing for KAC, Lordship. Lordship, I'm praying for 4 weeks time for filing our activity. Lordship, some development is there, Lordship. In the meantime, Lordship, negotiation was going on, Lordship, and respondent number 6 and 7, they have already received the amount, Lordship. And in respect of other petitioner, Lordship, the negotiation could not be complete due to election, Lordship. So we need some more time.
6 and 7.
Yes,
Where
6 and 7.
There is no 6 and 7. Petitioner number.
Petitioner number 6 and 7.
6 and 7.
Yes, they have received them.
Received the amount.
Yes.
Lordship will have the last order, Lordship, on 5/4/2024, Lordship. Same stand was made, Lordship.
5/4?
Same stand was 5/4, Lord.
Negotiation is going on.
Did not reach your Lord.
With 2 of the petition. And other petitioners are not.
Nothing, Lordship, because these are minor shareholders, Lordship. The majority ones, Lordship.
Okay.
All our businesses are demolished, Lordship. All our buildings are demolished, Lordship. And because of the stand they're taking, it feels more like a tactic, Lordship.
What is the interim order?
Interim order, no further demolition. Status quo in terms of the
Election time is the everybody is busy.
Lordship, Lordship, the only problem is let them file their affidavit, your Lordship, because
So we'll
sufficient
file-
time,
file it.
sufficient your time, Lord.
Mr. N. Gautam, Lord. And Sir
R.S. Rohan.
R.S. Rohan. Representing from A.
2, 3, and 4.
Wait for and is back. File. Affidavit. Being regard the is expected that A file on or before from same is expected you file interim order.
Item 34.
Please, my lords.
I see the next court number 15.
On lake.
Yes, sir. Court
Affidavit is ready.
Yes, your lord. Pleadings are complete.
Pleadings are complete. Sorry.
Yes, Mr. Sir, then we can pick where less number of cases are listed.
Sorry, would my lords hear me today?
No, because Mr. Kyle is also not available.
Uh,
Hold on.
Would my lords give me some date after 26th May? Sorry.
Three zero.
My lords, 3-0 is fine, and the interim orders to continue, my lords.
3-0. Third, Mr. R. Bora. Math.
MTech.
MTech. Get for that. For the Please, 05 2020 as it vital landmark. The interim order passed by shall continue. I think expected lesser cases that but met clear lot. Yes. Here in this case, the petitioners are husband and wife, lordship, and after marriage, lordship, they failed to get blessing of parenthood, lordship. Accordingly, they were pursuing IVF technology, lordship. And in between, lordship, what happened? The central government passed one act that your lordship will find, the Surrogacy Regulation Act in the year 2021. That prior to that, they were pursuing that IVF technology, lordship. Now, what happened? Because of this act, they were debarred from pursuing the surrogacy procedure. Accordingly, they filed one writ petition before this honorable court. And this honorable court disposed of the writ petition with certain directions, allowing that your lordship will find at page 42, relevant portion, page 42. And observation of this honorable court, your lordship will find page 44. Yes. And then lordship, page 45, lordship may kindly see that both of them again started the procedure. And page 46, medical report is there. Their DNA of their semen was taken on 1/2/2023. Then again, your lordship will find page 47, the central government issued another notification on 14th March 2023. After this procedure, again, restarting of this procedure. Page 47. Now, this has been clarified by the central government in terms of, in view of the order passed by Honorable Apex Court. So now, lordship, my only problem is that because of this litigations, lordship, now I am overage. This is the only problem, because page 47, which debarred, lordship, in taking semen from a donor, that has been clarified by their subsequent notification, which is now allowed during pendency of this writ petition, lordship. They again issued on 21st February 2024. That notification is amended. Page 47 notification is now amended. And now the only problem which the petitioners are facing is that they are now overaged in terms of this Surrogacy Act, lordship, which requires the woman to be around below 50 years and the husband to be below 55 years. And I have enclosed one judgment of Delhi High Court Division Bench judgment that your lordship will find at page 59, where similar issue was there, and their age was relaxed on the ground that they started the procedure prior to the effective date of the act. Page 59, relevant paragraph, your lordship will find 7 to then 11 to 14. Now, it is available in Assam now.
Now, Lordship, on last occasion, that
Gogoi,
That part, I don't have the expert. But
what
that
is the
liberty has already been given to them.
liberty is already
Liberty has been
granted
given
to us.
them.
Now the
For
only
any other
problem,
state.
yes, only problem is that age problem.
Age problem now.
Because of the subsequent notification and the litigations, Lordship, I am facing that repeat. Otherwise,
where is the
after
age prescribed?
50 years for the
Where
wife,
is the where is the
that
prescribed?
Surrogacy Act, your Lord. In the judgment also, Your Honor, your Lordship will find that
No, in the act.
Act 4, Section 4, I have given one book, Lordship. Your Lordship. C1. Lordship. Four small c. Four. Section 4, small c, then Roman 1.
Small c.
Yes. Then Roman 1.
Where is the amendment? The rule?
Rule amendment is page 47, your Lordship will find notification that the first notification regarding use of donor egg.
Because Mr. Ahmed,
Lordship.
not that technical term. After death, I think I stopped earlier.
Yes. Lord.
And thereafter, I have seen a few orders passed by Supreme Court on the same.
Yes, on after that,
Other dose.
I have annexed that your
No,
Lordship.
after this.
After this, Lordship, the Supreme Court has remanded the matters to High Court.
After this, I
yes,
have to,
yes,
where are
because
those orders?
that order, Lordship,
Because please place those orders also, Mr. Gogoi also, so that we can decide something this way or that way. And find out the meaning of the word substitute. Is 47.
that Lordship, I have.
You have no difficulty with this.
No, subsequently, Lordship, I have given
Amendment or no amendment, you have no difficulty.
no difficulty because
With page
subsequent,
47.
yes,
But
another
47 has
notification.
further been amended. Now it is in its favor.
Yes, that notification
During
I
the
have handed over to you.
petition, it has been amended.
Now only problem is with the
Age.
age. What are the other orders passed subsequently? Because I took up the matter on 18th. Thereafter, I have seen some order.
Honorable
On surrogacy, on surrogacy. Supreme Court order. Supreme Court order. They are clarifying and clarifying.
Verified, and because this notification was issued and subsequently all the matters were remanded to High Court because number of cases were filed. That I can place in short time.
Okay, let's go to, it will take some time because I have to understand it. Thursday?
Thursday I have some
This
difficulty.
Thursday?
On Monday, Lordship.
Monday.
The hearing that
I would have. You are
Lordship,
not there.
after some time, Lordship, I will give it.
Thursday not there.
I will be out.
Okay, you be there. We'll just examine and
Lordship.
but if some clarification is required, we'll find out. Okay, only on Thursday. We'll not pass the order in your absence.
Lordship.
But I have to need to go through because these are technical terms.
Lordship.
And I'm very poor in medical terms. Yeah, I come from for the City Council, health and health.
Tomorrow,
Oh, Kali. Take third, take third.
next Thursday.
Take on. Yeah. Who you? You.
May it please your lordship, the beach order appears for this matter. We have received our instructions, my lord. I'm appearing on behalf of, we like to file one short affidavit.
We last take the time and it's very urgent.
Trying to fit. 1 week?
Date may
2
be
weeks,
fixed.
2 weeks.
2 weeks.
Date may be fixed.
No, what is the subject matter?
The matter is the registration, GST registration. So due to default this amount in the lockdown and so the
Default on is on your part.
it's my part is that kindly see annexure 14, annexure 1, the registration certificate, GST registration. And then to default this amount, the show cause notice issued the page number 17 annexure. And in the 6 months, this show cause notice is uploaded at website and GST portal. So the petitioner is not aware about of the systems. So that's why there's no knowledge of show cause notice. So
So is there requirement to serve the locals notice?
Yes.
In person?
no.
No.
No. It's uploaded.
Requirement is uploading.
Yes. Only
As per the
uploaded.
statutory prescription.
Yes. So
My lord, this is our instructions that we have received, my lord.
So if the cancellation was there, then thereafter you made appeal.
after that, 88 annexure 3, page number 89,020.
It was cancelled.
The rest. Yes.
It was cancelled.
Yes, Lord.
Then there was an appeal.
An appeal is filed with the after 1 year. Come to the knowledge from the CA. So then filed an appeal. Dated is
It was barred by time.
2020.
It was barred by time.
Yes, barred by.
Now tell me how we can condone.
But lordship in persons with no that that's why.
No, did
And
you raise?
all are
That is one of the grounds in the appeal.
Yeah.
In the appeal, one of the grounds raised.
no ground is that the petitioner that the SN health issue for financial condition and lack of
There is a new ground taken now.
and all the deferred amount has been
Right.
so.
Can appreciate. But what is the remedy?
In persons, if the responsibility is in the notice in person, then and the petitioner can file an appeal and to hear and
See this instruction, madam. At least last paragraph 5. Whether we can revive the receipt. They have come up with a remedy. If that remedy is acceptable to you, good enough. Can we punish?
The delay of 1 year.
Paragraph 5. They have come out with a solution. Take a call. Right. Pay your dues. Close the earlier one. Get a new. You'll not be violating any condition then. And you can continue with your business. Only difficult will be you have to provide the new registration number to your clients.
But due to the lockdown,
On the law point of I don't find anything. Take a call. Consult with your client.
Yes.
And we'll, in the meantime, you prepare your affidavit. Right? We'll observe that this part. Hard MS
yes,
S. Chakraborty. Learned counsel for the petition. Yes, Mr. Gogoi. See the paragraph 5. And Mr. H. Borua, learned counsel representing Mr. B. Chaudhary, as standing counsel, Finance and Technical Department for the respond number 25.
So in this point, my lord, there are consistent that case of other cases I found. They've got some my lord, input tax rate. If they go for price registration, that gets them. Otherwise,
But where is the provision for law to revive? See,
no, there is no provision.
the problem is that he delayed.
Yes,
Or
admittedly.
admittedly, it was at his end. Delayed submission. Then thereafter,
A window
cancellation was made. Then he preferred appeal. Appeal was barred by time. Now, otherwise law that appeal if the barred by time, then some like so. This kind of litigation must come to an end. And some consequence he has to bear now.
Yes.
We can't help it.
Yes. And there is no question of sympathy. Right?
No question of sympathy.
Whatever is provided.
And appeal is barred by time. I cannot revive. That is also law that this kind of litigation must come to an end
A window
at
was
one point or another.
A window was open, my lord, for a time being. Perhaps that also, my lord, the petition did not appeal. There was orders, my lord, disposed by the honorable court, considering one notification of the central court. They gave that part. That also is over. By the
Take a call.
Okay.
Mr. Borua, Learning Council appearing for the respondent. Finance Department has submitted on instruction, if the petitioner is continuing his business, he can close the earlier registration by filing final return as per the provision of the Act by paying all his dues in the state return and thereafter, can obtain press registration. The Borua has the submitted that he will file the affidavit of position within 2 weeks' time. The prayer. Borua, how? MS Chakraborty. Learning Council for a petitioner shall, in the meantime, can in the meantime obtain instruction as to whether the petition is in agreement of the subject matter.
Allow us take this time to obtain.
Heard Mr. R. S. Vitro, Learning Council.
MTech.
MTECA. Council representing Mr. Estica. Who is available? Mr. P. Your name was or Mr. Chaudhary.
My name
Who? Mr. D. Gogoi and MS Dhaka. And competitive for what he has paid for and is granted has paid for 10 days time to obtain instruction. So one notice by CGST, one notice by SGST. So your contention is that two procedures on the same subject matter under section 6 is permitted. Whose was first? State or central? Or who reached the destination first?
State was first, my lord. Central
State issued first, so cause and central later. Then order in original pass or what?
order has not been passed, my lord. One has been stayed, my lord. Subsequent have to obtain, my lord. But at the time, order was not passed.
Election served a notice in
State 26 into state, my lord.
committee about ATC amounting to 1 crore 41,000. Component number 4. Advise the petitioner to pay the state amount. The state notice was served by correspondent of state. Up to 2023. Submitted reply to
basically demand is against the, my lord, demand notice by the central government. Now, my lord, central case.
Yes. Yes, thank you. Sorry. Maintain what a path. That proceeding is continuing.
No, yes, state is continuing, my lord. Yes, central statement.
We have not stated process.
No, my lord.
You take your instruction, Mr. Gogoi.
Yes, my lord. What is the outcome, my lord?
What is the outcome?
Yes.
Mr. Gogoi and sending us up-to-date instructions as regards the status of the proceeding initiated by
My lord, the notice dated 1/12/2023. So-called notice.
by
Yes,
so-called notice dated
1/12/2023.
1/12/2020. Take your instruction. If it is complete,
yes,
then same amount, second proceed.
Item 38, my lord. They have issued both, entire the actual state has issued both the orders, my lord.
38.
38, my lord.
Huh.
In here also, my lord, violation of section 6 2B, my lord. Yes, entire is also issued order as well as state is also issued notice orders.
The issued demand comes also
Yeah, it is first notice.
now here CGST is first.
State issued first notice, my lord.
Huh?
State issued the first notice, my lord. And
State issued first.
center issued second. However, center passed the order first, my lord. And
They reached the destination first.
first, my lord. After state also is the
They were
destination,
late.
my lord. But both the authorities have passed the order, my lord.
Now which order will you mean?
One order your lordship is state, my lord. Order
Which one?
passed the state, my lord. That is state, my lord.
Yes. Mr. Gugoi, you were first to issue the notice,
But my lord,
but late to reach the destination. They were second, but they reached the destination first. What to do?
My lord, state,
It is to be tested on the basis of 6.
my lord.
Nobody has filed any
no,
counter.
everything, my lord.
Your assistance will be required.
Both authorities cannot pass.
But how to?
So that some order has come from.
Okay, then take
On
it.
same day, my lord.
Same day. Arrest it from America. To be good and for listing after is the case is the interim order of
Maybe the lordship. Lordship may kindly peruse the order dated 8/4. Lordship, a submission was made that perhaps the department is contemplating withdraw the show cause notice which you have done. In this case, what happened? There is a judgment of Honorable Court in amalgamated. The amalgamated plantation, where it is said that in case of exemption notification, department is required to pay tax.
In case of?
In case of exemption notification, there is a delay in payment of the principal amount. Then department is liable to pay tax. Then the matter went to Supreme. Our SLP was dismissed. However, the document was kept up. In the meantime, similar cases were before December court dismissed the allow the repeat. And matter is pending before Supreme. In the meantime, many cases come during the petitioner. Then if this was directed to pay subject to execution of priority favor of the department. In case the department wants the case in Supreme Court, then they will refund them. In the meantime, let's see what happened on 14/2/2024. A notice has been issued by the department asking them to refund the amount. But if I talk to the department, because this notice cannot be sustained. The Honorable Court has explained the matter. The matter is considering, the department is considering to redo them. It will take some time. Because it has been placed. Without, I have make inquiry, they said that due to protective demand, this notice was. However, this thing has not been mentioned. There is a circular of the department where it says that if any matter is pending for a higher court, then the department is to notice, because all the notice are issued within a specific time. If it is time barred, then they cannot recover. But this case is different. Here, because their case is already by this one. So in this respect, to circumstances, probably department will withdraw the notice. It's already given my opinion to the department. But it's a matter of time. Another
Yes,
10 or 12. Because the matter is already held in court. The matter will
Let him come on.
Lord,
He has also given his opinion in your favor. You are protected.
Yes,
by
he
interim
is very protected.
Mr.
Yes, Mr.
Right, Mr. All the respondents?
All that.
All that. Mr. Kar. How much time?
2 weeks.
4 weeks.
2 weeks.
2 weeks. Time. Okay. Instruct as regards any decision taken for withdrawal of the demand from the court. Payment by the health. Please take the interim order passed out. Shall con-
If in this case notice was issued, if I required after 2 weeks time, so their claim was dismissed on the ground of delay.
Yeah.
Their demand was phase 89 NHL 7.
Yes.
Lord.
But Mr.
A2D.
A2D is uncomfortable. Certificate and then income tax.
Income
tax department for all that. And has got for and is granted to extend. So obtain necessary instruct to file conservative. What is this revised data?
Lordship is asking.
Rejection of revised application.
Yes.
Application for condoning delay in filing revised return, Lordship.
That power
There
is
is a
available.
there is a specific provision that we can apply for condoning delay within a period of 6 years. We had applied that call for documents for verification, and subsequent to that, they have rejected, saying that it is time barred, where time still is remaining, Lordship. That you could have given me liberty to file revised return, Lordship. That's the case.
What is the implication?
Lordship, I am due to change in
Monetary
the
implication.
Yes.
There's a I'm supposed to get a refund amount of tax paid, Lordship.
Is the amount proportion?
Amount will be Lordship 1,23,000 for 2 assessment years, Lord.
Is the question.
What of?
In this case, we need some time to file our
plan.
That I'm appearing for the state.
In all the
No, item number put together all the file our but another one is 2195, which was not discussed.
My lord, as per
42,
the last
you are repeat-
order, this item number 42 has already been segregated from the other two.
42, no?
Rana Saidur Zaman, item number 40 has been segregated from.
Mr. Mohan, you are appearing
And for item 41.
Okay.
In
42 I am appearing. L. Mohan, Granite Council for the petition. Mr. R.M. Tekka, Granite Council for the petition. And Trustee D. Dekka, Granite Council for the and M.S.
You Sharma,
You from Alani.
government.
For the purpose. In view of the order passed in WBC 1870 on 24 The said petition is to be received segregated. The said petition from WBC number 2087 number 2088 and what is your prayer time? No, no. 42, Mr. Anantaka is there.
My lord, today I prefer time to file a reply matter.
Sir. They come submitted. It have filed affidavit in opposition in all the three.
Yes, ma'am.
All the three.
Yes, ma'am.
In all the three. Mr. Anantaka. Mr. Deka.
My
to file an affidavit in opposition. Mr. Mohan, you also has also paid for and it can be completely Mr. Deka and a comfort of and if you back as already one method which was not there with 199. Who is the petitioner here? It was appointed because PSO and another one already go for 219. Mr. Deka. Council Court of submitted that the same petition has occurred another and the same petition along with 43 other things.
item 42, there is an interim order is there. It may kindly be continued.
The state of the interim order the interim order passed earlier on
1442.
3/4/2024, much. 3/4/2024. Deeply
That is
the
only,
case after 3 weeks in terms of the observing main date.
my lord, the interim is only operating in one.
Right.
item,
This is
40.
what I have
Yes,
observed.
my lord. Yes, my lord.
deeply open.
Deeply obliged.
Please, my lord. My lord, herein we need some time.
Why it has come forward?
But actually, the steps on the respondent number 5 have not been effected by us. The respondent number 4 has filed affidavit, my lord, which clarifies their stand.
It's not dusty.
My lord.
You are permitted dusty or what?
Yes, my lord.
Which one of 5?
The Lat Mandal.
So what is your opinion?
My lord, the circle officer has filed an affidavit, my lord, clarifying their stand, my lord, so which will be sufficient, I think, my lord. We may kindly be allowed to file a rejoinder to them.
Right. What about this? You're not taking steps about respondent of 5.
Lordship, that was the lapse on our part.
Huh?
Your
So what
lordship,
to do with it? It
Lord-
has come for that only.
lordship, if your lordship deems fit, then kindly allow us to take fresh steps.
Mr. S.A. Learned Council for the City has not for 2 weeks time to serve the notice of the response of by way of the state. And you are enjoying interim order?
Yes.
3 weeks time. And to file a compliant affidavit. The response of such affidavit will appear in by is law. It's very kind of affidavit. That's it for one vote.
Interim order.
Okay.
Already
Interim order.
affidavit
The
has
interim order passed.
affidavit has
Let them file a reply. It is on the record. Yes, somebody made a morning.
May it please your lordship.
5 and
Lordship,
6
I am appearing on behalf of SD Prakasto. Lordship, the respondent have filed affidavit.
respondent number
Respondent
5
5
and
and
6
6 file.
Notice has been served. Please respond number 8.
Your lordship,
8.
we need a counter.
You should have
We
first
need a
mentioned
counter.
about the
Counter them by
notice note. Order of the Lajima Court. Should have mentioned about the order of the Lajima Court first. Hard, Mr.
Your lordship, we need a counter. Counter
Hard,
them.
Mr.
SD Prakasto.
SD Purakayasto. You are not SD Purakayasto.
No, on behalf of SD Prakasto.
Mention your name.
A Islam.
Okay. And now for the petitioners.
My lord.
NMS.
3, 5, 6
Central Government Council. Huh? CBA. MSM. Formal Current Government.
2, 3, 5, 6, 7.
5, 7. NMS. E. Begum. And in view of the order dating. Twenty-six, 2024. Commander Service it is treated to be complete. Mr. Ben has made for saves time by that's one.
Maybe wrongly listed in the order.
Why your yes, anything required? Further, they have exercised the discretion already given.
I'm not in this.
Huh?
I'm not in this.
You are fogging a dead horse
My lord,
since last 2 years.
Check, my lord, after issuance of notice on 26 and 2022, we don't have any extra copy. Probably doesn't survive, it is not surviving.
Where is Mr. Karim?
Yes, my lord, I am on behalf of him, my lord. I am
Yes, where is he?
left the court because of
He is
his health condition, my lord.
just putting one more number of repetition in the board. That's all. Adding burden to the judiciary. Fogging a dead horse.
When I have not
Mr. MS
RR Bora.
R.R. Bora, Learned Council, appearing for the petition. Learned Council appearing for Mr. A.A.R. Karim, Learned Council. Has sought listing of the FIDD. FIDD. Listing of the please the case accordingly. You are fogging a dead horse.
May I please, Lord? Amended cost title was submitted by implementing APDCL as a party. APDCL was made as a party, respondent 7.
Made a party.
And accordingly amended cost title was
Received.
submitted.
Initially, Chief Electrical Inspector was not made a party member. After court order, he was made party member. Accordingly, we have received the report also.
Notice. Notice. Newly implemented one number 7. Newly implemented one number 7 means
Chief Electrical,
APDCL.
Chief Electrical Inspector.
No, Assam Power Distribution Corporation Limited, represented by the managing director, shall be added as respondent number 7.
Lordship, actually the matter is pertaining to the non-payment of accessory relief. They have no part.
Whatever court has passed an order.
Yes, Lord.
The coordinate bench has passed an order. You have filed the amended cost title. You notice the newly implemented respondent.
7.
Have you served the copy?
Yes, Lord. Copy was served.
Sir, Arteka, Learned Council Court of Petition. Any revenue? Here amount. 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 3, 4, 5. Release the case. After we check the name of the learned standing out. APDCL. The respondent's right record.
Lordship, affidavit was not submitted by other respondents. Direction was for filing affidavit in opposition.
Let him come. After we
Obliged.
Lordship, in this case, we need 2 weeks time to file the affidavit in reply, Lord. Give you some
affidavit in time. Yes, the product.
I file my report.
Mr.
J. Das.
J. Das. Mr. Das. Wait. Which time? Other 2 weeks. To file affidavit in time.
Right.
What time? None has appeared. For the return down. The video of 55,000. Await for the report. As we can file.
May I please your lordship? Lordship, response number 3 is for award for service response number 3.
3.
Response number 2 has by filing their wakalat number.
2 has appeared.
Okay, this case was filed alleging non-compliance of order dated 25/8/2023.
Where is that order?
Okay.
Page?
Prior order. Page 11.
Yeah. Yeah.
Okay. Subsequently, one IO was preferred order.
Right. What is that order?
The interim order was vacated, Lord.
So first, 25/8/2023. Where is that order? Annex? Annex there?
Not
Okay,
annexed,
here.
Lord. I have
It's here. Page.
on, yes,
Page
25/8
21.
25/8 is there.
What is the interim order? Provided that petition shall not be evicted from the land in question until the existing. Then therefore,
One IA was preferred, Lord. It is IA 3442/2023 by the National Highway Infrastructure Development Corporation Limited.
is it part of the record?
Not. Okay, I can furnish the copy. Okay, the first one is the order passed in the IA.
Yes, madam. Again, talking a dead horse. Your interim order is no longer in existence. Because you admit that this is the order. 24/11/2023. Still you are pursuing with this contempt petition for last 5 months. No time.
Let my senior come.
Who is your senior?
Armudu.
R. Mojumdar. We have to do. Miss,
J. Ghosh.
on the prayer of Miss J. Ghosh, stand comfortable. Yes, sir. Nothing. You need this one?
Yes.
Need this one?
Not file furnish again.
Okay, I'll just record. The instant contempt is preferred, alleging violation of the interim order dated 25/8/2023. 4700/2023. Mr. Nayak, standing counsel, Supreme Court,
Response number 2.
has submitted that by an order dated 24/11/2023, an interlocutory application, IA civil number 344/2020, the interim order dated 25/8/2023 has already been vacated, and the said fact is reflected also in the order dated 24/11/2023, passed in the petition supplementary number 47/2000. Post of MS and has talking of the case on Monday in order to obtain instruction. Monday. Take it.
This contempt is for non-compliance order at page 10, Lordship. Direction part at page 15, Lordship. Direction was to pay compensation against the land acquired under the Zamindari Act, Lordship.
What is the order?
Order is page 10, Lordship.
I report.
Direction part at page 15, Lordship.
What kind of competition? Land.
Lordship.
Land.
Lord.
I
Okay,
have
then what
submitted
happened?
one order, my lord. It automatically goes on.
Order.
Yes. And for respond number 1 and 3.
Order means okay. Short. Yes, rejected.
I've just seen the inquiry report, Lordship.
Read the order. Have you received a copy?
I've reduced, Lord. I'll take one copy.
What is the copy? It is not received by the client. Inquiry report and claim is rejected. Their names are there. WBC 6279. 6279.
6281, Lordship. Today.
6281. Okay, it is there.
Yes.
Okay. You can challenge this by press repetition. Otherwise, you have to. Sir?
M.R. Chaudhary.
M.R. Chaudhary. Current counsel for the petition. Oh, it is already there.
Yes, sir.
It's already there. Did you become legible?
I did.
And MS. E.R. Mohan. Current counsel. Paying for the response number 1 and 2. Okay, you are 1 and 3. 1 and 3. And Mr. H. Current counsel for the response number. The present convict was prepared, alleging violation of the direction made in an order dated 8/2020, common order passing to repetition by number 279 packet of the petition hearing who had a petition of WPC number 681. The repetition WPC number 8/1/2021 this was carried to the respondent number, respondent operate to consider the case of the petition for compensation after carrying out a verification exercise. MS Mohanto has placed of an order to hearing number 2020 passed by the number 1, whereby the case of the contempt petitioner, that is the petitioners in WBC number 681 to 2021 has been received in view of the compliance value made in the order with the passing of the act in view of the issuance of the order 12/2000. It's those the petitioners are aggrieved by the order date 12/2024, comma, the petitioners are entitled to be submitted as permissible under the law.
May I please, Lordship? But I, for substitution of the legally on the date of the petitioner, my lord, file this instance, I petitioner died on my lord, 2024.
Who died?
And death certificate on my 15th February. So then thereafter file this instance. Item number 1.
Yes. Yes, MS Gormo. Art Planning Council for the MP. Betray for the Planning Council for the both department. Yes. MP. MS for the part. AR?
TL
Yeah.
for
EL. Planning Council part. Yes, sir. uh, one Abdul Jabbar Ilyas Jabbar as the store in expert converted nine uh, the level one comma but by the taking up it Abdul Jabbar on the ground Abdul Jabbar Ilyas Jabbar has expired command duty of the on 24 01 of the effective date of when it happening happening of the date when command has been command reporting the date Abdul Jabbar by the date of uh, the applicant has heard that after the date the right to sue has survived and they are legal and instantly right within the liquidity period of the public date by the uncovered is not by the uncovered part of a trying to of the learning council for that topic of that to impact
Lordship, against a common order passed by Board of Revenue, 4 writ petitioner has already filed a writ petition, and Lordship has allowed this writ petition and set aside the order of the Board of Revenue. Lordship, one has left out due to some misunderstanding, Lordship. That was left out. Ultimately, he has filed a petition, and this another court has allowed the petition, concurring the judgment passed by your Lordship. Thereafter, Lordship, his order was not complied with only on the ground that Lordship has in the final order, Lordship has pointed out, page 58, Lordship, and the Lordship order. It starts from 58, Annexure 9, Lordship got it. Finally, Lordship has passed an order as page 83. Finally, Lordship has pointed out, Lordship, as corollary mutation in respect of plot number A, plot number 2, plot number 3, plot number 4 stand restored in the name of respective petitioner, the authority concerned shall act accordingly. There shall be no order as caused. This is the final order. Hereafter, Lordship, this petitioner also approached this court by separate writ petition, and this honorable court passed an order at page 86.
Yes.
Lordship will finally see 86. It appears that no notice or earlier issued a private respondent in this case, even the submissions made by the petitioner counsel that matter has been amicably resolved. Taking note of the submission of Goswami and prayed for petitioner's counsel, writ petition stand disposed of in terms of the order dated Iman, passed and connected writ petition. Writ petition stand closed. Lordship got it. Yeah. But this order was not complied with by the authority on the ground that the plot number was mentioned in the earlier order. There is no specific order. That is why it was not complied with by the board. The other petitioner has been.
Today, why it has come?
Today we have
Who is
taken.
this respondent of 5 and 6?
We have taken steps against the private respondent who has filed the appeal before the Board of Revenue.
Bring them on record then.
Lordship.
Now you serve them copy. Earlier they appeared.
Earlier they have filed affidavit to that effect that we have no objection. They have filed
Right.
affidavit to that effect. Now we
Bring
have taken steps also.
It is
My
not notice
question
issued
is
hardly
whether-
on 22nd April. It has gone only on 22nd April.
After returnable the Lordship may take.
My instruction says that they have already corrected.
Corrected.
Probably
Lordship, because we
Komal Krishna Goswami, son of so and so, in a land record covered by DAC number 727. Check KB Patra number 1223.
No, Lordship, before filing this petition, we have made a complaint to the Deputy Commissioner. Then, Lordship, they have, I think.
Take it, we can post it.
Lordship, I will take it.
Jamabandi copy is also.
It is there.
Lordship, I can take her a copy.
Art is the ethics of chartered council. Mr. A. Bhattacharya, Learned Standing Council, Revenue and Disaster Management Department for the response number 1 and M. Borman, Learned State Government for the response number 4. MS M. Borman, Learned Submit, comma, on instruct, comma, that the plot of land, comma, covered by DAC number 727 and KP Patra number 123, comma, situated at village Bentusi, Moza Beltola. Has been land record pertaining, has been corrected in the name of Sri Komal Krishna Goswami, comma, son of that Orchestra Goswami, comma, the writ petitioner in WPC number 3467,000. Mr. Goswami, Learned Council for the People, has sought this thing of it after we in order to complete his instruction. List the case accordingly. Get the copy from MS form, find out your time, visit the office, check. Why it has come for?
May I please go? Malord, in this matter, Malord, the auction that was challenged, that has
Who is
failed.
seven?
Yes. So 54 and 55 are the connected items.
Who is seven?
7 is Malord, the lessee who was originally Malord there.
Dennis Pura.
Yes. And Malord, he had created the mortgage in favor of the bank. So we challenged the auction that was to be.
Service is not come. Are
Yes.
you enjoying some order?
No, Malord, we are that auction, that order has lost its force because the auction has failed. So there was no bidders were there. So Malord, as far as whether Malord this cause of action survives or not, let me take instruction. Let it be posted next week.
Hey, Ganguly. What up? Mr. B. Gogoi.
Respondent. Assamti Corporation.
Just technical.
No, we have been
Direct for respond number.
One and
Two. Only two.
yes. In fact, only one and
One and
based on I
one and three. Which state has hormone? Hormone is there. And hormone. Number three. Here are the yes. MS D. Goswami. And calculator number 4 and as per 20 0,000. Mr. Ganguly has submitted the
Failed.
You like it. In fact, as to better study before start.
Next Friday. Next Friday.
Monday.
Yeah. Sure.
Same in other one?
Yes.
55.
Same. Yep.
MS
P. Agarwal.
P.
Agarwal.
Agarwal. Current
What's
council
the
for the petition.
service is awaited in the
So, sir, in view of the office not dated 22/4/2024, await for the report as legal service of number 1.
Service commitment so far.
Service complete.
I'm applying for respondent number 6. I have filed a Pakala number today. So we'll file the affidavit in opposition.
Okay. Mr. as what?
Manoj, we'll file the affidavit in opposition.
Hormone you appear for? 1 to 5.
1 to 5.
And MSM hormone and Mr.
S.A. Bakhtiar. For
S.A.
Bakhtiar. Bakhtiar.
Bakhtiar.
Bakhtiar. For
Planet Council has submitted that he has entered appearance on behalf of the respondent number 6 today.
Yes.
By filing
Pakala number today. So can you grant us 4 weeks time
he has
to file
paid for
4 weeks time
and
to
he
file the
granted.
affidavit in opposition? 4 weeks time to file the affidavit in opposition. Your Planet Council will not be available. This is now still
Only when a date may be fixed.
4 weeks time will be there to file the affidavit in opposition.
4 weeks file affidavit. Yeah. Respondent was status. They also never filed their respect. It is the court. Admission.
All right.